Good morning, everybody. Good morning, Dr. Matatoka. You don't want to just see if you can, because I shared I opened the platform for you to share the presentation. You don't want to just see if it works for us, please, ma'am.
Thank you so much. I will ask my colleague now to just try that out. She's the one who will be delivering the actual presentation.
Thank you so much.
Thank you. Hi, colleagues. I hope you can see. I think we are able to project.
Dr. Dennis, yes, we can see the screen. Can you just try and move it also for me quickly, please, so that we can see if it moves?
All right.
There we go. Perfect. Perfect. Thank you very much. and your sound is excellent. So thank you very much.
All right. So what do we do now? Do we take it off until it's time for the presentation?
Yes, yes, please.
All right. Thank you.
Thank you.
Recording in progress.
Honorable members, good morning. Firstly, my apology. I will not be able to switch on my video. I'm on the road and my line is a bit unstable. As we start, I'm going to request that Honorable Direko can pick up in case my connection falters. But for now, let me request that we all observe a moment of silent prayer and meditation. Thank you. That way we declare the meeting of the Portfolio Committee on COCTA open, and I want to welcome all the members. When I get a stable line, I'm going to request that we show our faces. I see we've also got some long-lost faces. Honorable Taiposh, I see you are back. We welcome all the members. We do have the committee quorum, and therefore we are ready to go. May I request Sherin to table the agenda for this meeting to adopt and proceed. Sherin? We have on the agenda the issue, firstly, opening and welcome, which I've just done. We'll obviously acknowledge the apologies, and then we have the presentation, excuse me, from the Commission for Gender Equality on two issues: access to communal land and illegal initiation schools. And then thereafter, we will have a discussion, and then the briefing by the department on the local government municipal structures amendment bills on coalitions. I'll say a bit more about that at that point. Then we welcome the CRL and go through that discussion at that point. So that is our agenda for the day. May I have any comments or move for adoption or any amendments? Any mover for adoption?
I move, Chair.
Thank you very much, Direko. May I invite a seconder? I cannot see.
Chairperson, I second.
Thank you very much, Honorable Van Veek. So the meeting will then proceed with that agenda. We do have an apology. The minister is stuck on other work, and the deputy ministers and possibly Deputy Minister Benz Ngamashe will be joining a little later. And so we will then proceed with the meeting as indicated in the agenda. Thank you very much, honorable members. May I therefore at this point welcome the Commission on Gender Equality, led by the Chairperson, Advocate Ntabiseng Sipanya Mukhale, Commissioner Mulalo Nemataheni, Commissioner Bongani Ngomane, CO Dennis Matotoka, HOD Naledi Selebano, and Head of Office of the Chairpersons, Ms. Notemba Sonjika. That is the list of the attendants on the delegation from the CGE. I'm going to request that the chairperson presents the delegation and then take us forward with the presentation. The chairperson of the Commission for Gender Equality, please proceed.
Thank you very much, Chairperson of the Portfolio Committee, Dr. Mkhize. We actually really appreciate this opportunity. As you have said, I'm here with 3 commissioners and the CEO of the organization, Dr. Matotoka, and our HOD for research, Ms. Naledi Silibano. Chair, I just wanted, as opening remarks, just 2 lines to say we as the Commission for Gender Equality, as you know, we are supposed to monitor and investigate where there are challenges that we see or where we actually feel we want the country to understand better what the dynamics are with regards to gender equality. And it is against this vein that we actually went out to investigate these 2 areas. And we have felt that we cannot have our reports just gathering dust in our office after investigations. And then we then started this whole campaign of approaching the relevant portfolio committees with regards to the relevant reports that we have in our organization. You are the 4th committee now that we have presented various aspects to. So we go to whatever the issue is that is relevant. Why we're doing this, we feel that sometimes when we give feedback to either the government department or any other sector of society without bringing to the attention of the portfolio committees, we are missing out on an opportunity for additional oversight. We actually feel that it is important that you, as the ultimate oversight, as the representatives of the people of South Africa, know what is happening in the different sectors and work with us to oversee that the things that we find on the ground, the things that the communities talk about, are actually brought to your attention so that you can continue to monitor with your departments. So it's against this backdrop, Chairperson. I just wanted to give that background. With those few words, I will then allow Dr. Matotoka and Naledi to do the presentation without wasting time. Thank you.
Thank you, Chairperson. We will be delivering the report firstly on the exploring barriers to women's access to communal land in selected provinces in South Africa 2024-2025. This is one of the reports that we had focused on during the financial year 2023-2024, which was also a build-up on one of the campaigns that we've held pertaining to One Woman, 1 Hectare campaign. Now, what we are saying, Chairperson, we are acknowledging in terms of land, that land is often looked at from a race perspective and not necessarily from a gender perspective. We view land as one of the key instruments for women and marginalized groups to escape destitution. From an economic perspective, from a safety perspective, we then resolved that it is important to assess the extent to which women are able to access land in South Africa. Against this, Chairperson, we will then start with the presentation, which we will take you through the mandate of the Commission briefly, discuss the problem statement. Due to time, we will not touch on the legal framework that we've looked at. Suffice to say, in every investigation that we conduct, Chairperson, we look at both the regional, international, as well as local instruments that aims to foster gender equality in our practices, especially the state as well as the private sector. Mr. Silibano will then take you through the aims and objectives of this study, the methodology that we've embarked on in terms of the research study, and then take you through the comprehensive findings as well as the conclusions of the study, closed with the recommendations. With that being said, Naledi, then we can take the committee through the presentation. Thank you.
Thank you very much, CEO, as well as the chairperson. Good morning to the chairperson of the Portfolio Committee, honorable members, commissioners of the CGE, the CEO, and colleagues. Thank you very much for laying that foundation, CEO. I will follow suit as you have briefly indicated in the overview. I've noticed that I only have 30 minutes. However, this is quite a lengthy presentation that covers 2 reports. However, I'll do my best to cover as much ground as possible within the allocated time. It is on the exploring barriers to women's access to communal land in the selected provinces of South Africa. That was the title, both in 2024 as well as the recent report that we produced in 2025. And thanks CEO for taking us through the table of contents. I will not go through that again. Just briefly on the CGE mandate. The Commission for Gender Equality is an independent statutory body established in terms of, okay, this is blocking my view. Let me just restart. Apologies. For some reason, technology these days is always against me. I think I have it now. Apologies for that. The Commission for Gender Equality is an independent statutory body established in terms of Section 187 of the Constitution of South Africa. We are mandated to promote respect for gender equality and the protection, development, as well as attainment of gender equality in the Republic. We have powers as the Commission, and they are outlined in the Commission for Gender Equality Act, number 39 of 1996, and specifically in terms of Section 11(1)(a) of the Act, it states that the CGE has the mandate to monitor and evaluate policies and practices of state organs, state agencies, public bodies, and the private sector to promote gender equality as well as the rights of women, and that we must prepare reports and submit such reports to Parliament. In terms of a brief introduction around this presentation, in the 2023 as well as in the 2024 financial years, as the CGE, we conducted a study to explore barriers that inhibit women from accessing communal land in rural areas of South Africa. The first report covered the Northwest, Limpopo, as well as the Eastern Cape. We then endeavored again in 2024, and we focused on the Free State, Northern Cape, KwaZulu-Natal, as well as Mpumalanga. And as the CEO indicated, these projects build on the 2015 CGE campaign on the 1 woman, 1 hectare of land, which aimed to promote gender equality by proposing that the state must allocate at least 1 hectare of land to rural female-run households. The campaign was premised on the idea that when women have access to land, their families are generally better nourished, that women flourish because they would have access to better education, leading to overall advancement. And the problem statement, we stated in the reports that the issue of land access in South Africa is often discussed in terms of race while overlooking the gender-specific aspects of land access. However, we noted that women in rural communities face numerous barriers that hinder their access to land. The CG also noted complaints coming directly to our offices of women struggling to access communal land in the country. And we also noted as an issue that land insecurity tenure for women in rural communities can be attributed to discriminatory land distribution rules, social practices, as well as patriarchal norms that were created to favor traditional leaders as well as men to the exclusion of women. We also stated that in the context of South Africa, we could not ignore the legacy of apartheid laws, especially because there were regulations in the past that relegated women to the status of minors, subjecting them to the authority of their fathers and husbands, particularly in this area of land access as well as land ownership. And we noted that in the present day, in the democratic dispensation, women still continue to face similar struggles. They face challenges that relate to discriminatory and unjust practices, as access to land for many women in communal communities or rural communities is still tied to male relations through marriage as well as kinship. The traditional authorities often elevate the status of men above that of women, regarding them as the head of the family and therefore restricting women from independently accessing land. And we noted that this exclusion is usually done under the guise of protecting marriage as well as families or traditional values. We noted that land registration through the PTO process remains deeply entrenched in patriarchal norms, as newly married women may be required to re-register land that was acquired while they were still single under the name of the husband, only putting themselves as spouses or as joint owners. We noted challenges around the fact that divorced women may be expected to leave their land after a divorce, especially if they choose to remarry. And for widowed women, land may be transferred to the husband's brother upon his death, while unmarried women may be evicted from their homes, and that they may be further prohibited from inheriting any assets by their married brothers. We noted that currently communal land is under the control of traditional authorities. There are instances where they are the land is registered under trusts as well as communal property institutions. And we also noted that there's often conflict that arises between constitutional democracy and customary law due to the pluralistic system under which land is administered currently in the land. And we noted that these two systems, the democratic or legal or written laws, as well as customary laws, that sometimes there are divergent views, and that women in rural communities often struggle to navigate these conflicting systems, leaving them in a vulnerable position regarding access to communal land. I will skip this slide as indicated by the CEO, given the time constraints. However, the study was premised on both international as well as domestic legal frameworks. I will go to the aims and objectives. So the aim of the study was to investigate factors that act as barriers to women's access to communal land in the selected provinces. And the objectives were to explore the social, cultural, and economic factors that inhibit women's access to communal land in the country. Another objective for us was to investigate the effectiveness of current institutional as well as legislative and policy frameworks in promoting women's access to communal land. Now, this was a qualitative approach, which is an in-depth inquiry that focuses on understanding meaning, experiences, context, as well as processes, rather than measuring quantities or testing hypotheses numerically. So in essence, we were seeking to explore the why and how, as opposed to how many people, for example, experience various phenomena. So this study was qualitative. In the first instance, we had 128 participants. We had women who participated in the focus groups in the 3 provinces, and there were 110 in total. And then we also had the participation of traditional leaders as well as community leaders in the provinces as well. And we had the participation of 18 in this financial year. And then in the year that followed, when we continued the study, we had a participation of 151 women from the 4 provinces. We had the participation of 66 traditional leaders. We also interviewed government officials, and we had a representation of 9. We had civil society as well as experts in this thematic area, and we had a participation of 12 of those. So in total, we had 238 participants. I will skip that slide. We did consider the ethical considerations. Our studies follow and observe the following ethical principles on informed consent, voluntary participation. We observe confidentiality as well as anonymity, as well as beneficence, which means doing good or doing no harm when interacting with human subjects in our research. In terms of the findings in the Eastern Cape, under leadership structures, rules, and procedures, we noted that in the Eastern Cape, there was a demonstration of diversity in how land administration was carried out, because there were different structures responsible for allocating communal land in the various districts of the province. There were structures that were democratically elected by the communities themselves, whilst others relied on the selection of the senior traditional leaders, and the same also applied when it came to the councils, the traditional councils. And all of these structures were responsible for creating rules and procedures for the allocation of communal land. What we noted in the study is that very few women served as senior traditional leaders as well as head women in the Eastern Cape. And there were instances where participants mentioned that women were not eligible to serve as traditional leaders. And in areas where they were represented in leadership roles, the study found that they had very little control over the rules and procedures. In fact, women felt that their role was to maintain existing rules and procedures, including those that were rooted in patriarchy. So women felt that they had very little room to influence how the administration of these structures would be carried out. In terms of family structure and related dynamics as a theme, we noted that in order to access communal land, one had to be between the ages of 18 and 21 to be eligible. These rules apply differently in various villages under different tribal authorities. And we noted in the findings that there was a woman from Ngecha village who was over 30 years, meaning she was eligible based on some of the rules that had been indicated. However, she was still living with her parents. And she mentioned that it was very difficult to make money in farming in her area due to access to communal land. She expressed that she had a passion for farming and mentioned that she had been applying for a lease for the past 7 years, but was denied access. And in her own words, she shared that it is even more difficult as an unmarried woman who does not have children. The participant said that her brother was not struggling, had not struggled to access communal land in the same way as she did, even though he was unmarried himself, and that she, on the other hand, had to be at least married or have a child before she could be had. There were areas where we also noted findings that related to issues of sexual orientation. So sexual orientation, gender identity and expression were additional factors that affected access to communal land. There were participants who expressed their views in the Idujwa area, and they stated that there is reluctance to accept gender diversity and a prevailing belief that individuals should conform to cisgender norms, with findings revealing that members of the LGBTQIA+ community were not recognized or even welcome in the area. Members of this community were not allocated land, as it was believed that they did not exist in the communities and that they had left or migrated to urban areas due to rejection by their own families and communities. One participant said the following in the focus groups. She said, "Never, they, referring to queer individuals, are not welcome here. You can't give birth to a girl a girl child, and then they choose to become a boy. A boy is a boy and a girl is a girl. So the statement that I've just shared illustrates that homophobia and transphobia were sanctioned and utilized to ostracize queer individuals in some of these communities. There were economic barriers, and we noted that the overall cost implications in terms of accessing communal land are quite high, especially for those who do not have stable employment or a source of income, particularly for women because they experience high unemployment rates and are generally economically marginalized. We noted that the cost ranged from 100 rands to over 100,000 because each tribal council or authority had its own rules as well as fees that they were applying. In some cases, applicants were also required to slaughter sheep or chickens and cook for the entire community during the land allocation day, along with having to buy bottles of alcohol, which made this process even more expensive. And we noted that land that was closer to towns or newly developed villages were even more expensive, ranging from 40,000 rands to 70,000 rands or more. It was, however, unclear where this money went, as the views varied. Some believed all of this money went to traditional councils, while others said the money goes directly to Cooperative. And we noted that the criteria for determining these prices was very obscure as well. In the Northwest, under leadership structures, rules, and procedures, participants revealed that power was mainly invested in the senior traditional leader, as well as the royal house or royal family, in terms of land administration. As such, even though women had specific quotas in traditional councils, they did not really have much power to allocate land or make rules. We noted that the basic rules for applying, especially for residential purposes, involved producing an ID, birth certificates of children, and a marriage certificate for those who are married. However, we also noted a challenge when it came to waiting periods for allocations. We saw that these waiting periods differed because in the Royal Bafokeng area, they seemed to be quite longer as opposed to other villages that we visited in the same province. And that participants noted that they were not given clear reasons as to why there were these delays. Participants cited cases of applicants who had been waiting for over a decade, in some instances, for a response, while in other villages, it was very easy. The waiting period was about 2 weeks to 3 months. In terms of culture, norms, and traditions, we noted in the findings that there is different views in terms of acceptance of the relevance of cultural beliefs, especially those that seem to discriminate against women. And a pattern we noticed in the data is that women who were advanced in age, those at least who were 60 and above, were more amenable to accepting culture and tradition as it is, whereas women who were younger, between 20 and 40, felt that the traditions or culture in their respective villages needed to be reviewed. We also noted as part of culture, norms, and traditions that there were different dress codes that were expected when appearing before the headman to apply. Men were required to dress a certain way, wear trousers, a shirt, and a jacket, while women were expected to wear dresses, cover their heads, and wear a scarf around their necks. This is okay. However, in instances where individuals do not conform to certain gender norms, this was a challenge. For example, a trans woman who did not want to present in a way that was expected in the community felt that a dress code served as a barrier, because if you're not dressed in that particular manner, you cannot appear before the headman. And if you cannot appear before the headman or the head woman, therefore you will not get access to land. In terms of family structure and related dynamics, in the Madibogo village, the rule stipulated that land allocations must be made to the firstborn male child of every family. And this rule mainly applied where the father was absent due to various reasons, including death. We also noted that there was an age restriction. This applied across many villages in the Northwest, that men had to be 40 years of age. However, if they were married, it was fine. They did not have to meet any age criterion. With women, they had to be represented by their husbands if they were married, and those who were unmarried had to be represented by an elder. It could be a man or a woman. We noted, however, in Tsitsing village, which is in the Royal Bafokeng area, that women had to be at least 40 years, while men had to be 40 or 45, especially if they were unmarried. And what participants noted in the study was that the rules were stricter for unmarried men than they were for unmarried women. And in most cases, men had to adhere to this age requirement. And for them, as community members, they felt this was a tactic to encourage men to get married. In terms of economic barriers, the study found that the senior traditional leaders have authority to determine who receives land, its location, timing, as well as the size. And in terms of accessing communal land, we noted in the Northwest that the fees seemed to be the same across the board. There weren't instances where we learned that the fees change based on the conditions. So it was mainly 500 rands. And then in the Bafokeng area, if you were not a resident there, you had to pay extra, and that amounted to 850 rands. And there were also annual levies that ranged from 20 rands to 50 rands. But in that village, it would be the same for everybody. The 50 rand or 20 rand would apply across the board. For business purposes, land was provided at no cost, even though there had to be strong motivations that needed to be made. And what we noted is that among the 3 provinces in the study, the Northwest was the only province that had a consistent application fee in the villages. So what we also noted is that women in the Northwest were seemingly in a better position than in the other 2 provinces, meaning the Eastern Cape and Limpopo, even though we noted that there were significant delays when it came to allocations in the Royal Bafokeng area in the Tsitsing village. And what we note with these long waiting periods is that they hinder the ability to start businesses or live independently with children. And as a mitigating factor, some of the families divided already existing land in the family among its children so that they could also start building their homes to live independently with their children. So in the same yard, we would find that it would be partitioned and shared with children so that they could start their lives due to these long waiting periods in the area. In Limpopo, when it comes to leadership structures, rules, and procedures, we learned that leadership structures were responsible for land allocation, and the structures include the royal family, the traditional council, the village committees, as well as headmen from respective communities. And one needed to approach the headmen if they wanted to apply for land, who would then register the application and send it to the tribal authority. And applicants would then get an opportunity to specify the place or land which they are showing interest in acquiring. It was mentioned that if a community member is considered to be taking too long to develop the land, it would be allocated to someone else, and the window period was about 2 years, even though there were challenges here, and I'll speak briefly on them later in my slides. Participants indicated that in some instances, due to the high demand for land in the province, the 2-year period was not adhered to. In fact, participants, particularly in the Ntabalala village, mentioned that stands could be allocated to 2 individuals at the same time, citing similar reasons that you took too long to develop your stand, even though the 2 years period would not have lapsed. But sometimes it was due to financial gain for the headmen, and senior traditional leaders were also alleged to partake in these practices, as well as other members of traditional councils. So 2 stands would be allocated because there would be fees that are charged, and that money would be appropriated. The participants also mentioned that due to these money-making schemes, women who were allocated stands would be taken advantage of, especially if they were single. As stands would be allocated to them only to be given to another person who would usually be a man. Some of the women in the focus groups mentioned having to cohabitate with a boyfriend as a security feature or some form of security, because a man would then be able to stand up to another man. And one of the participants said the following: if you don't have a husband or boyfriend, the headsman's eyes will be on your stand. If you perhaps travel for a longer period, or you don't erect, excuse me, a building structure quicker, like they can see no action, he can resell your stand. And you will hear by someone telling you that this is their land, and it is usually a man, and you will lose the stand. So being single and owning a stand is very difficult. There was prevailing corruption, as alleged by the participants, and one of the other participants shared the following: here to get a stand, you need connections, and perhaps you need to be beautiful so that the chief or headman or the person selling the land listens to you when you negotiate. It's like you are looking for a job. In a nutshell, what I'm saying is you need to bribe someone. Although predominantly male, women were also included in traditional councils as members. It was noted that despite being aware of corruption, traditional leadership structures were not taking any steps to address it. With regards to family structure and related dynamics, in the Moleji area, we noted discriminatory practices against women. Women were expected to have children for their land application to be considered. Marital status was also found to be a factor. And one of the participants said the following: it is what the other lady said, referring to another focus group participant, that if you are not married as a woman, or you don't have kids, or a man that is not married, they won't give you a stand. It is common. It happens in these villages. Participants explained that when community members tried to understand why these were the rules, they were told that unmarried people or those without children are considered to be unstable, so they will abandon the land. In Ganana, it was mentioned that it was part of cultural practices that female children must move out of their homes because the property must be inherited by male siblings. One of the participants said the following: that's why you see many of us here living in these shacks, in our stands. As vendor women, you are taught from a young age that you must leave your home because it does not belong to you, but to your brothers. It is how it is. We are raised like that. In terms of economic barriers, corruption was said to be widespread in Limpopo, with traditional leaders accused of benefiting from it. Participants informed us that their prices for applications differed. For example, one of the participants said the following: For business or a place of residence, as already mentioned, the application ranges from 500 to 15,000. However, there are additional fees such as 850 rands for the PTO, 50 rand to 450 for being allocated a piece of land that is preferred. And there were also 20 rand and 50 rands annual levies. Another participant said, getting a stand is not difficult, male or female. Here, your money advocates for you. I bought my stand for 3,000 rand, only to find out a few months later that my friend bought hers for 4,000 rand, but living in the same area. Hence, we say that the headman or the chief charges anyhow, but it's pricey if you are not working. You won't manage. And there were instances that in the same focus groups, participants would only find out then how much they were each charged, which led to some disputes because others would say, but I only paid 5,000. Another one would say, but I paid this much. So there wasn't transparency, it seems, in how the charges were made. I won't read that. I'm looking at the time. However, a point that I wanted to make is that when we spoke to an official from Cogstar, they indicated that the standard fee that should actually apply is 1,000 rand, meaning the other charges that were being made were not regulated. In fact, this quote that I won't read was speaking to the fact that when women, or in fact individuals, but they were speaking from their perspective as a woman, that when you want to acquire a stand for business, there were traditional leaders that would say it is fine, pay the fee. However, you must note that whatever you make, 50% will belong to the headman or traditional leader. In the Free State, we noted that there were complex application procedures, including documents that were required. However, a noteworthy finding is that in some of the villages we went to, there was a higher representation of women in the council structures. And as a result, what we noted that in the Free State, although there were challenges, they seemed to be not so high as compared to other provinces. And we thought we could attribute that to women dominating structures and therefore making rules that would favor all or be equitable in the allocation processes. I won't go through the process of application. However, I will speak to the application fees. They did range from 105 to 40,000. And these differed depending on the village or community. And also there were requirements rather in terms of documents. I won't mention those that are similar to other provinces. And what we also noted, which is, I think, worthy of mentioning, is that once an individual chooses to remarry, the property remains because it must be inherited by the children, and those who choose to remarry must then go out of the home to look for another piece of land to occupy. What we noted as a challenge in terms of socioeconomic barriers is that due to high unemployment rates and limited access to resources, these application fees are quite hefty and burdensome for women to carry. We noted the extreme poverty in the province that in some instances exceeds the national averages. And that rural women, specifically, or women rather in the rural communities, carry the disproportionate burden of unemployment. And many of them were engaged in agricultural activities, mainly for subsistence farming. What we noted as a key finding was that there were government initiatives designed to promote women's access to land. However, they were cited as hindering opportunities because in many instances, it is women who already were in business, who were already established that were securing such opportunities, and those who were new entrants were struggling. So this was noted as a barrier. And what we noted was then a key, in fact, the recommendation that came up directly from the participants that support must be provided for women who are in startups so that they could be capacitated and enhance their livelihoods. However, there weren't a lot of challenges that we noted. Where they existed, they were mainly around the urban-rural divide, especially when an area was seen to be a communal land or traditional authority that's closer to an urban area. There were challenges around access in that regard. But yes, we covered this in the report at length. What we noted in the study was that even though in some instances the participants felt that there weren't many gender discriminations or biases, in our own analysis, we encountered challenges. And it was difficult for us to make comparisons. So while participants would say, here we don't have many challenges with gender discrimination, we could not really back this up with data. And data was a challenge, because even when you approach COPTA to say, please give us statistics, or even the Department of Land and Agriculture to say, please give us statistics in terms of land allocation by gender, also in terms of the hectares, etc. That information was not available. So we could not take it at face value that things are just perfect. We needed to back this up, but unfortunately this data was difficult to get a hold of. I'm trying to now rush through the process. In KwaZulu-Natal, I will specifically speak to this area. There was a low female in the traditional councils, meaning that women's interests were underrepresented in decision-making. One of the participants said the following: even though there are 1 or 2 amakhosikazi in KwaZulu-Natal, it's just for numbers to fulfill government requirements for representation. But I bet they don't take or make decisions. They are just there to listen to amadoda. And then the participant went on to say, because that's how Zulu culture is, umfazi akakwazi ukuphatha nokulawula umuntu wesilisa, meaning a woman cannot lead while men are present. What we also noted is that although government frameworks existed, they were poorly communicated. There wasn't really much awareness of them and supportive policies to ensure application as well as enforcement. I'll try to skip areas that I feel I don't have to spend time laboring on. We noted that traditional leaders lacked explicit guidelines on communal land matters, and the absence of clear national laws, regulations, and policies created opportunities for corruption, reinforcing gender disparities in communal land access. With the Ingonyama Trust, we could not directly interact with the board. They refused to speak to us on a number of occasions. However, when we spoke to communities themselves, they reported that a number of their policies undermined women's land rights, that women were compelled to sign leases through male proxies, effectively stripping them of direct land ownership. And in some instances, the Ingonyama Trust Board or local traditional leaders insisted that leases be registered under a male person's name based on the presumption that a man must head the household. In terms of the fees, they also differed from one municipality or tribal area to another. In some instances, it was 1,000 rand. In another, it was 1,800 rand.
You have 10 minutes. You have 10 minutes to conclude. Please proceed.
Thank you very much, Chairperson. And in another area, it was 5,000 rand. I'll go to Mpumalanga due to time constraints. A key finding was that only 6 out of 61 senior traditional leaders were women, effectively making it about 10%, showing that there's a gender imbalance. We also noted that corruption was prevalent and that headmen demanded extra fees for land access. There is, I think this is the slide that I would like to touch on. Women expressed experiencing threats and intimidation. I'd like to read this quotation where one of the women said, "We are intimidated daily by headmen. I have received threatening messages on my life and my family as I am a widow raising young girls. I have a gun to protect myself. I have no other choice. There are young boys who wanted to steal my land, which I found lying idle, and I cleaned it myself. They came in and threatened to take it, so I bought a gun and chased them away." Another one said, "As a single parent widowed, I have had encounters that almost cost me my life and those working close to me. A few months ago, as I was on my farmland, we were attacked, ambushed by gentlemen who came to send a message for me to give up the land, as my husband had died. The men in question had guns. They tied us upside down on the trees within the farm. They took away my car and other belongings." So these are just some of the threats that women, especially those who were widowed, experienced. I will now just rush to the conclusion, unfortunately, because of time constraints. So based on
if we can just go to the recommendations, please, because this is where the committee will be interested on, please.
Thank you, CEO. I will do so. In terms of the recommendations, as the CGE, we recommended that key departments, including, I struggle with this, but I'll say it as it is, DALRRD and COCTA, should take proactive steps to enact comprehensive legislative frameworks that effectively tackle the enduring gender disparities in access to communal land, and that this legislative framework development must involve targeted policy interventions designed to bolster the implementation of gender provisions. We also stated that the legislative and policy mechanisms must establish robust measures that not only safeguard women's land rights, but also incorporate clear accountability mechanisms to ensure enforcement. We also said in the recommendations that customary laws should be harmonized with constitutional provisions that promote gender equality and safeguard against discrimination based on gender, sex, and sexual orientation, particularly in relation to land access. That this alignment is crucial for creating a legal framework that not only supports equal opportunities for all individuals, but also addresses historical injustices and empowers marginalized communities in their quest for land rights. We recommended that women's active participation should be enhanced in traditional leadership frameworks, land governance structures, and decision-making processes, which are essential for cultivating a more equitable and just society. That COCTA must pursue initiatives aimed at amplifying women's representation within land governance and traditional leadership structures. A pivotal strategy could involve increasing the existing 30% quota for women's representation in traditional councils to 50%, and that this adjustment is vital considering that women comprise the majority of the population in the country as well as in rural communities, that this increased quota will ensure that women's voices and perspectives are significantly represented, leading to a more inclusive and informed decision-making process that benefit all members of society. We noted in the recommendations that COCTA should prioritize the development of of comprehensive strategies aimed at enhancing representation of women in senior traditional leadership roles, as well as head women, because these positions hold significant power and influence within decision-making processes that are related to land allocations, as well as associated procedures and practices. We also said by empowering more women in these crucial roles, COPTA can foster a more equitable and inclusive environment that acknowledges and integrates the perspective of women in stewardship of land and resources, and that these efforts must also include women with disabilities as well as the LGBTQIA+ persons. We said in the recommendations that data collection, monitoring, evaluation, oversight, and reporting are essential functions that have largely been overlooked by the two departments. That to effectively address this oversight, it is crucial that the departments create comprehensive technical indicators that incorporate gender disaggregated data. We said also that the technical indicators will enable a more nuanced understanding of progress towards equity for women, particularly persons with disabilities and the LGBTQIA+ persons in relation to their land rights. That establishing such measures will not only provide clarity on existing disparities, but also foster accountability and drive meaningful change in land rights policies. That fostering collaboration among government entities, civil society organizations, and non-governmental organizations is essential in tackling the complex social, cultural, and institutional, as well as economic barriers that hinder women's land rights. That efforts must focus on enhancing public awareness and legal literacy, empowering women to understand their rights fully and to navigate the legal pathways in order to secure their tenure. That enhancing access to justice is pivotal, particularly through the provision of legal aid specifically designed for those seeking to assert their land rights. That this support should include not only traditional legal resources, but also accessible and affordable alternative dispute resolution mechanisms. That formalizing access to commercial land for women is crucial in empowering them to actively engage in business and agricultural activities. That this initiative has the potential to significantly expand their economic opportunities and improve their livelihoods. That to address the significant gap in access to traditional banking systems, the introduction of strong financial inclusion programs is crucial, and that one of the effective approaches could be the implementation of microfinance schemes specifically tailored for women residing in communal land areas. And that training and capacity building is essential for government officials as well as traditional leaders. And we also said it is important that the ministers linked to the two departments must demonstrate genuine political will to effectively implement strategies aimed at closing the gap and addressing the inequalities that exist in women's access to land rights. That without this commitment, efforts will remain merely theoretical, lacking the necessary action to bring about meaningful change. Thank you, Chairperson.
Just on time. Thank you very much. Let's hear if the CEO or chairperson wishes to put any of the last words before we start the comments.
Chairperson, yes, I just wish to bring to the attention of the committee that this issue of businesses coming into rural areas and accessing land for free perpetuates poverty and dispossession of rights for the locals, because you end up with your shop rights and all of those malls and everything coming in, getting huge patches of land, and whereas the locals are made to pay. That's number one. Number two, we are not even sure that those malls and other things that set up in the rural areas actually provide jobs for locals. But the other thing is now with our porous borders and everything, we're going to end up with people who are non-South African coming in, setting up businesses, employing South Africans, at salaries sometimes that are very below so the entire Bill of Rights is being undermined by this sector, or that which has got laws and rules and policies that are very fluid. You know, we stand a chance of having rural people's land being taken by outsiders or by local business without any, what you call it, for them. I just wanted to clarify that, whereas it's the same people who go back home regularly, are building massive houses, some of them, invest in the area, but never feel they belong in the area and stand a chance for the area to be, taken by somebody. Thank you. Sorry, CEO.
Thank you, Chairperson. Just for me, one thing, Chairperson, if you were to ask us as the CGE, what do we want to achieve out of this presentation today, Chairperson? It's more oversight on the committee that we are requesting. We will be writing a letter to the department. I must put on record, Chairperson, that we have a good working relationship with the department. That's fine provinces, especially in Mpumalanga. So we'll be having a meeting with the department to share some of this recommendation. We, however, request, Chairperson, that from an oversight perspective as the committee, this must be an area of interest to the committee, where the department is expected to provide also progress report in terms of implementing some of the recommendations that we are putting forward as the Commission for Gender Equality, because in our view, the attainment and achievement of this requirement of these recommendations, they need both the committee, the CG, as well as other institutions to work together for the realization of gender equality in as far as access to land is concerned. Thank you, Chairperson.
Thank you very much, Chairperson, CEO, and the presenters. Indeed, this is an interesting initiative that originates from the Commission for Gender Equality as a way of interpreting its role, and it's a matter that is quite topical and does need attention. Certainly, the issue of the management of communal land rights is an issue that remains with a huge amount of uncertainty. And it's not only this aspect, there's a whole issue as well that relates to, I think what the chairperson was relating to, the safety or security of the communities' access to their own land vis-a-vis the competing commercial incursion by commercial enterprises who are able to find their way around the communities and then take certain advantage of the available land. So there is certainly a lot that needs to be discussed on this issue. In particular, the question of the framework through which the rights to land tenure to the communities has to be regulated, standardized, and also ensure that people remain with their assets without really losing in the process. So I'm going to request the members to make their comments.
Hello.
If you could just...
Yeah, Bonjanma.
Aibo. Who is not muted here now? Who is not muted? Who's Lindelihle Mkhwanazi? Please cut him out. Take him out of the platform. Please cut him out of the platform. Honorable members, we now would like to invite you to comment. I see the first hand, Honorable Van Zyl. Could the other members indicate? Please proceed. Honorable Mkhalip, you'll be next. Let's proceed. Honorable Van Zyl.
Thank you, Chairperson. It's quite rainy here by me, so I'm going to switch off my video just in case I do cut, if that's fine, but it is me.
We can recognize you. You're welcome. You can cut. At least we've seen you are not a ghost. You are a real person.
Thank you, Chairperson. Thank you also to the CGE for the first presentation. I have a couple of questions which I'll just run through quickly. Given your findings across all the provinces, I mean, from Eastern Cape to Limpopo, which you've shown us, it shows that women still cannot access land without a husband, a male relative. How is that possible, that this level of discrimination persists 30 years into democracy? And what concrete steps has the CGE taken to hold traditional leadership structures accountable for these violations of the Bill of Rights? Then just on the second question, your study also showed us that there's consistent patterns of extortion and bribery and unexplained fees from 100 Rand to over 100,000 Rand, depending on the province. So I'd be interested to know if the CGE can indicate which cases it has actually referred for investigation or prosecution, and whether any traditional leaders have been held accountable for this. Then your recommendations also repeatedly calls for harmonizing customary law with the Constitution. We all know that this has been said for over a decade. What is the measurable implementation plan? Who's responsible, and by when must communities actually, or will they actually see this change? And then lastly, just in almost every province that you studied, applicants had no title deeds, no formal land ownership instruments, and no protection from eviction. But those are all obviously constitutional rights. Has the CGE advised COCTA or the Department of Land Reform to fast-track reforms to the PTO system, and what has been the response? Thank you, Chairperson.
Thank you very much. Honorable Mkhaliphi, you'll be next. You are muted. I'm sure you can hear yourselves. We can't hear you. We can see you.
Okay, Chair. The network is bad here. Can I switch off my mic?
No, at least we've seen you. Please proceed.
All right.
You can switch off.
No, thanks, Chair. Well, I welcome the report, and one must also indicate that we are not surprised. We are aware of such patriarchy that is still experienced by women in this country. So we are also thanking the CGE for the study that paint a very clear picture, of which I'm not shocked myself. We know what is happening in this country in terms of women liberation, especially in the rural areas. So I'm not shocked at all, Chair. So now, therefore, the study has been conducted by the CGE. I just want to check in terms of the implementation, because we, as the department, we must ensure that the constitution of this country is protecting everyone, including women. It's very embarrassing that by this time we're still talking about the women not having access to land, particularly in rural areas. And in order for women to be recognized, must be led by men. Even if you don't have Mkhwenyana is passed on, you are told that no, in fact, you must have a son, as if it's your choice as a woman. If you are giving birth, you must give birth to a male figure. If you don't give birth to a male figure, it means you are going to be oppressed forever. So therefore, I'm saying, Chair, there are laws. There is a constitution that protects women in this country. So therefore, I want to ask, as much as I saw the recommendation from this report, that they are also asking the COCTA committee to help. I agree. Many people, more hands. It will also need that we need to fight in all angles. But the CG have powers empowered by the Act of Parliament, is empowered by the Constitution. I want to know, what are the plans from the CGE to implement those laws, that legislations that are pro-women, in order to avoid such painful presentation that we receive, Chair. We have a house of traditional leadership, even at national level. I want to understand from the CG part if they have already tried to implement the Constitution of South Africa. We have to start somewhere. I agree with those percentages of how many women are represented in terms of the leadership in traditional council, but we have to start somewhere. We must come here in the committee to debate that the traditional council have refused to implement the Constitution and progressive laws of South Africa. Therefore, definitely sure the committee will be on the side of the CGE. It's not going to oppose or to try to understand or debate whether this law must be implemented or must not be implemented. But without a clear plan from the CGE, the committee won't be able to assist as much as we want to assist. Secondly, I was listening to the chair, the comments regards to the businesses, also citing the fact that there are also an element of people outside from South Africa who also ended up owning land and building businesses and pushing away women is what are trying to address the matter. I think let us get our house straight in order first to say let us use the platform that we can use to implement our own laws. And once we strengthen that party, chair, it will be easy also to protect women from the outside world now. There are businesses who come with money here who want to push women away, but now let us start somewhere. House of Traditional Leadership and the Provincial House of Traditional Leadership, do they understand that they don't have to oppress women as we are no longer in democracy? Those are my contribution, Chair. Thanks.
Thank you. Honorable Direko.
Greetings to the colleagues and the Commission. Chair, I must also echo the same sentiments as my colleagues have just said. It's really, really embarrassing to listen to the presentation because it portrays the South Africa that we never thought we'll find ourselves in. And Chair, it's also bad to realize that after 30 years of democracy, women are still subjected to such environment, which really needs government to do its work. And also the law enforcement needs also to do its work. Chair, listening to the presentation, I'm also going to emphasize on what Honorable Marina has just asked. In the presentation, they've raised issues of corruption, which I believe that if corruption is the order of the day in terms of land distribution, it must be reported to the law enforcement. So I would like to check with the Commission that in their finding, has they been coming across this element of corruption, and what have they done with those allegations that came from the findings? Secondly, they also raised about the issue about the single women. So I also want to check on the cases of single women. Are there any element of gender-based violence that have been also identified? And if they are there, what has the Commission done with regard to that? If there's no cases that have been opened regarding those allegations of corruption, and also if there are cases of gender-based violence, we'll also want to know that so that we can take it up with the relevant law enforcement. Thank you, Chair.
Thank you. Honorable Taiposh, welcome, and we are so happy to have you back, and we're grateful for your recovery. You can show your face if you are in a space too, so that member can recognize it's still you, but you are now next on the floor. Please make your comments.
Thank you, Chair. Good morning, colleagues and the members of the CGE, honorable members. Chair, for the sake of quality, I think everybody's seen my face. I will now put my video off so I can have better audible quality. Thank you. Chair, you know, I will start with the intricacies of customary law. All right. And I'm happy that the Commission for Gender Equality is there. But I think what they need to do, we're going to have to take a step back, and we're going to have to come back to land reform and COCTA and get them more involved so that there can be a legal framework governing the ownership of land for women in rural areas. Unless we do that, it's going to be very difficult, because even within the different tribes, the rules are different. You know, So there's no blanket coverage of these things, and unfortunately, customary law for some people it's very difficult to accept. For some, it's very difficult to change because that's the way things have been and that's the way it will be. So, like I said, without a legal framework, and it must be enforced by COCTA as well as rural land development. It's going to be very difficult. So I want to appeal to the Commission for Gender Equality that we need to start with a legal framework in terms, and then we need to approach the different tribal houses, because I promise you will find, and as you've seen for yourself, the rules change from tribe to tribe. So there's not going to be a single decision that's going to cover all, because some of them refuses bluntly that women will be in a position of power or decision making within within their tribes, and that is wrong. We've moved on. We've moved on from there. So that's the one thing, Chair. And then the other thing that I wanted to check with the monies that are collected. I see the monies are going to COCTA. I thought it should be going to rural land development, because COCTA is not in charge or in control of land, as far as I'm aware. So if we can just get clarity on that, okay? And yeah, it is high time. It is a long time, long overdue that customary laws has been, it's time to be reviewed. However, we know that with COCTA and land reform to regulate what happens in the rural areas or traditional affairs, I don't know, it's not priority with them. I'm sorry to say it. Personal experience, it's not priority with them, because here we are today. How many years later, the Khoi and the San has still not been acknowledged or even recognized in this country, because you have National House of Traditional and Khoi and San leaders, you have Provincial House of Traditional and Khoi and San leaders, but you have no Khoi and San leaders serving on those or in those houses. So good luck to the Commission for Gender Equality, but I'm happy that you are there and to take care of this matter. Thank you very much, Chair.
Thank you very much, Honorable Taibosh. Honorable Labuskaghni, followed by Van Wyk.
Good morning, Chair. I'm also just going to put on my video so that you can see it's me. I just want to ask, some of the questions have already been covered, and I think we all know that culture and custom laws and it's not that easy to be changed by bringing in new legislation, as proven by the findings of this report. And it's a long history that is not a comfortable one for anyone of us. I would like to know,
Jordan,
will the Commission...
How did your father sound?
Taibosh.
I would like to know if the Commission already had or will also present this report to the House of Traditional Leaders. And then also, I would like to suggest and ask if there is, say, 3 priorities out of this whole report that the Commission might be able to say, these are the 3 key priority things that the COCTA committee specifically can start focusing on to try and see if we can help this process and contribute to some changes in gender equality, because as it is, it's a lot of things to do. And my finding is when you have all these things, it's very seldom or it's very often difficult to say this is where this committee has to focus, because you said you presented to various other committees and each and every one is going to say, okay, we're going to do this and we're going to do that, but then it will not be coordinated and it will take another meeting to coordinate who is going to do what. So, I think it would be a good start to say, from your point, from the research and the knowledge, what you have, to make a recommendation to the committee, maybe through your chair in writing, and say these are the three most important things for this committee to focus on. Thank you.
Thank you, Honourable Van Zyl. Sorry, Van Wyk.
My chairperson, thank you very much. Greetings to the commission and to everybody else, my colleagues. If it's fine with you, chairperson, I'm also going to put off my camera and proceed. Chair, no, the report was very comprehensive. I really enjoyed the depth of the report. It was well researched and so on, Chair. And honestly speaking, we can't allow that in this day and age that women are being discriminated so against. But yeah, the problem that I'm having is that I can see that almost all the provinces in South Africa was covered by CGE with this research. But what actually concerns me is that we also have Khoi and San communities in South Africa. And when I look at all the parts that was covered with the research, it doesn't seem as if the Khoi and San communities, like the Nama, the Griqua, the Kurana people in all the other provinces was covered, where they also have the same challenges as women, and where there is even mines operating there, but women can't even get mining rights from the department to go and mine on their own land. So even though the report is welcoming and the research was very well done, that is my only concern, Chairperson, that the CGE must really look into the Khoisan communities as well. We have a case there in Patani in the Free State where there is a clash where a Griqua woman wants to they want to farm with hemp and cannabis, but they are being oppressed by the CPA there. Even in Saron, here in the Western Cape, you have women there who wants to also go into business, but the land was sold to foreigners. And that project of them was an old project. It's not a new one, but they were never considered as women. So I would just like the CGE to also look into the Khoisan communities as well. Thank you very much, Chair.
Thank you very much, honorable members. We've heard your comments and your questions. May I invite the commission? Could your delegation open your cameras so we can see who is there? But please start the responses. You'll just deal with them in the way that you had arranged from your side. But we'd like to see those who are responding as well, at least just to be able to see who we're talking to, even if they may switch off later. So let me request you to just show you all your videos, and then please proceed with the responses. Thank you very much. Yes, yeah, welcome. At least some of you have got the names at the bottom, so we know whose face it is. Let's proceed now with the responses. Those who haven't shown themselves, please do so.
Thank you, Chairperson. We'll be taking the questions. I'll be taking the first questions, and then Naledi will then close in terms of the technical aspects pertaining to some of the questions, especially those that I may have missed in terms of the questions. Chairperson, firstly, we welcome the questions and the comments that were made by the committee itself. This is quite encouraging from our end. So first and foremost, would like to say, yes, indeed, it is concerning that since the advent of democracy, Chairperson, we still have these discriminatory practices that discriminate unfairly against women, particularly on the basis of their gender. And that is actually the reason why, Chair, we wanted to go into this study, because we wanted to understand what seems to be the problem and what is it that is leading to women not accessing land. We have seen cases where women, Chairperson, they need to build their own houses for safety reasons. They could not do so because some of the requirements were very much problematic. And we are saying that in as far as cases pertaining to corruption, these were the allegations that the participants made when we were doing the study. And they were, of course, cajoled to say these are matters that needs to be investigated by the South African Police Service. But because of the sensitivity of the matter and the fact that they may be left in destitute, Chairperson, some of the participants were not keen to take these matters forward with the South African Police Service. And that is where, Chair, we need to go to the nuts and bolts of the real issue there, where people must be free to report cases without fearing any form of recrimination or victimization when such cases are reported then. And we are saying, Chair, in as far as customary law is concerned, we've said there must be harmonization with the key legislative as well as constitutional prerogatives in terms of the Section 1 of the Constitution, where we are saying that there must be dignity, there must be transparency and equality. And for us to really harmonize that legislative framework, Chairperson, we need to have a discussion. I think as a country, we need to have that discussion. And that discussion requires the department to spearhead it. It requires the participation of the Law Reform Commission. It requires the CGE as well as like-minded institutions, your CRL Rights Commission, the South African Human Rights Commission, to be part of how can we really harmonize existing customary law to really deal with the discriminatory practices that we are seeing. Customary law is not static, it is a living law. It must evolve as the culture evolves and some of the practices, and that's where we are coming from. And then from an implementation perspective, Chairperson, we first and foremost acknowledge that us saying we want to meet this committee was a need to highlight that our plan was to bring all the key role players together. And we've identified your committee as a very critical stakeholder that can assist to fast track some of the recommendations that we are putting forward, which we will take you through now. And there is a question around the traditional councils. One of the things that we actually observed with interest in the current framework, the traditional courts framework, it is very specific there, though it's yet to be implemented. It has carefully included the Commission for Gender Equality as an institution that must monitor how gender equality is fostered within the traditional councils. And I'm happy to say, Chairperson, though the Act is not yet implemented, that is a very critical area that the Commission in any event was busy with. We have a very good relationship with Pochimukwena in Mpumalanga, wherein in terms of traditional councils, they have already allowed us to participate, observe, and assist them in terms of how certain matters can be handled and how issues around gender equalities can be prioritized within the traditional councils. As something which we would like to see across all provinces, and that is why we talk about the need to have political will for us to really foster transformation within the traditional councils as well. So, of course, there is a definite need to see women representation improving and equitably represented within the traditional councils. And then in as far as the legal framework is concerned, Chair, I would like to, as I've said, this one needs key role players. And the Law Reform Commission needs to be involved, the department as well. And we would like to really participate in that so that the recommendations that we are putting forward can really be prioritized. And by asking the question, what would be one of the major the priorities that we'll put forward to this committee is precisely around opening opportunities for this legal framework to kickstart at a consultation level with the departments as well as the Law Reform Commission. And then we will be in a position to provide quarterly reports in terms of the steps taken to really establish such a legal framework going forward. Because with such a framework, we believe that it will address a majority of the challenges that we have seen in the sector. Not only in terms of access to land, Chair, but even in terms of some of the discriminatory practices that we continue to see in different sectors of society. And then the issue around, let me just make sure I've captured this correctly. Okay, have we engaged with the traditional leaders to really present this report? We had an opportunity, Chair, to launch this report in Limpopo recently with the House of Traditional Leaders. It was a stakeholder engagement, and the report was presented, though those that were in attendance still had reservations to say, are we reflecting a true state of affairs in terms of specific areas? And we said we would like to then engage them further if they have different statistics or information around how some of the traditional customs are being practiced by certain communities, particularly around Muleji, as it was indicated by the traditional leaders there. But we are saying, Chair, we are open to continue to engage. So we have started those engagements with different traditional leaders to bring this report to their attention and ask clear action plans to report, or rather not report, implement and address some of the challenges that we have seen there. I will then hand over to Naledi to then cover those that I may have missed, and then also to the chair of the commission for any area that I may have omitted. Thank you, Chairperson.
Thank you. You may proceed.
Thank you, Chairperson. Thank you, CEO. So I'll respond to the question around including the question in the study. Yes, that was the intention in the beginning for us to cover them. Where we came up with challenges, it's when now it was time to find translators. Because, the CGE using public funds can procure from the CSD. We struggled a great deal to find translators who would be able to look through our transcripts and translate to English, because as members can see, the findings are translated from native languages to English. So as a result of that, the coverage was limited. But because in this sitting, I could not touch at a great deal on findings from the Northern Cape, I wanted to just state that in the Platfontein area, there were a few Khoisan individuals or communities that participated. It was a struggle in terms of interpretation during the data collection process, but here and there we were able to cover their insights as well as their perspectives and views. But I do take note of the comment from the Honourable Member. It is important that when embarking on studies of this nature, that we cover all ethnic groups because they may be affected in sometimes unique ways. And I think that's it in terms of the technical questions, because of a lot of the questions were around our action plan as the CGE. I hope that covers it. Thank you, Chairperson.
Chairperson, thank you.
Thank you, Chair. I'll ask Commissioner Molalo just to respond to an issue that she would like to highlight. Commissioner Mataheni, please come in.
Thank you very much, Chairperson, and greetings to honorable members. So in line with our presentation, we have also noted that there are instances where patriarchal norms are taken as tradition. And sometimes as women, they do not know their rights. As one of our recommendations, we spoke about the importance of public awareness and also legal literacy, because when people don't know what their rights are, it becomes very difficult for them to want to exercise those particular rights. Another thing when it comes to issues of implementation, as the Commission for Gender Equality, we do provide oversight, monitoring, and also investigate and engage with different stakeholders, which is why this sitting today is very important, so that we can outline what we found during our investigation and also the different issues as we targeted different provinces in this regard. And we are indeed in connection and in collaboration and support with the work of the House of Traditional Leaders, as indicated by our chairperson, also doing capacity building and also highlighting the importance of the act that is coming into play. Thank you.
Thanks. Chair, from my side, I would just like to add and say we are ready to engage with yourselves to start working on a framework that will point to the harmonization of what is what the Constitution says versus what exists out there, and how we could bring it in line, because every single person is subject to the Constitution of the country. That's the first thing. But secondly, I also just wanted to say we also need, maybe you could do it from your side in terms of the research muscle that you have, to look at all the legislation that apportion rights to historically disadvantaged persons, so that even that is brought to life. I'm thinking about the Conversion Act. I think it's the Conversion Act of 1988 or something, wherein, 1993, yes, leasehold, certain rights to leasehold act, yes, conversion of certain rights, where people in certain areas were actually, with leaseholds, were allowed to convert that to ownership. And it happened, including trading. That's why those townships, shops, etc. And for me, it is silent on rural areas, and I do not see why it has not been included, because it talks about anyone who has got any rights, be it occupation rights or whatever, for them to actually be afforded the opportunity of ownership. So maybe it's those things that we could test and take to court, or even amend to expressly include rural areas where they are encouraged to have their land registered at the deeds office and a certificate is issued. And that's all sometimes that the protection that women want. But the Conversion Act does say anyone. And the purpose of it is exactly there, to redress the landlessness of the past. That is where we could start. Thanks, Chair.
Thank you very much, Chairperson, and to all the commissioners. Let me welcome Deputy Minister Benz Ngamashe, who has joined us. We will give you opportunity in the next session when we deal with the next item, and you might comment on whatever you wish to include what we're going through now. I don't want to rush you, so we'll get you at that point to come in to comment. But as we close this matter, let me commend the Commission for the research that you have done. There are a few issues I think members have raised. To start off with, we do believe that it's within your rights to have done this research and highlight issues of the inequality, gender inequality, where they exist. On the question that were raised, I think the issue of the Ko and the San community, your explanation is not convincing. most of the Khoi and the San communities use Afrikaans. You don't have too many communities which are basically using the indigenous languages. And so I think you need to look at that as an issue where there's a huge amount of grievances about exclusion. So keep that in mind. Secondly, the issues that you have raised, the members have asked the question whether you have found it possible or necessary at any point to lay charges where you think there's been specific transgressions that have been brought to your attention. I don't think the response has really covered that in a manner that we would understand. So I think just have a look at those issues. The third issue relates to the fact that the number of departments, but particularly the Department of Land Affairs and Rural Development, which is primarily responsible for the issues of land redistribution, land reform, security of tenure rights. It's one major department that has to address this matter, but joined to it is the Department of COCTA. What we would like to get from you are specific decisions in terms of what did you ask them to do over what period, because then it's easier for this committee to monitor whether what you have issued as the guidance of what they need to do at a certain time, that we are able to anticipate as you give us reports, as we meet with them, that we are actually able to make them account or accountable for the activities that are expected from this research. So I think you need to give us that much more explicitly so that we are able to see how to follow it up from our point of view. You're making a request for us to make an opportunity for legislation on issues of land reform, on issues of communal rights and security of tenure for rural communities, particularly under traditional leadership. We accept that. We are then saying, so far as the Department of COCTA will be involved, we would obviously want to work with them and help to facilitate the participation in the formulation of such legislative framework over the administration of the land, particularly as would be part of the responsibilities of traditional leadership. So with that, from our point of view, we believe that a lot needs to be done. As I said earlier, obviously the issue on the security of tenure on communal land is a matter that really has not really been addressed. And so we would like to urge the relevant departments to move with speed to deal with those particular issues and therefore address them. In the context of that, then of course we have to ensure that issues of gender equality and gender discrimination are addressed. And I think these issues have become very pertinent when we have to deal with the framework of how we use the land as the primary asset for our people, for stable communities as well as economic advancement. So from that point of view, we are all going to be together as we deal with those issues. So the rest of the details of issues that relate to discriminatory practices would support the Commission on Gender Equality about the need for widespread educational programs that will make people learn a new culture of human rights, equality, and gender parity, so that as part of their day-to-day interaction, we can actually reduce the pressure, the prejudice that comes from patriarchal and traditional systems that may no longer be suitable for the life that we lead under a democratic dispensation. Now, that obviously is going to be an ongoing process for which we must all commit that we need to actually help the communities to understand how to balance between all of those, whether it be in terms of the role of women in the leadership and traditional structures, access to land, and also respect of those women who may have lost or may not be having any of the male partners, that they actually have got equal protection in terms of land, access to land, and obviously the social protective norms within society, so that the issue of equality has to evolve in that particular direction. It does require quite a lot of educational programs. With that, let me say thank you very much to the members of the committee, and thanks to the Commission on the presentation. We will hold this matter at this point. I'd like to take you to request you to take us to the next presentation. I'd like you to move to the next presentation. For that one, I would like to give you 15 minutes to table the presentation, and at the end of it, we will ask the Department of Traditional Affairs to comment, and of course at that point I'm also going to request the Deputy Minister to come in. Thank you very much. You may then proceed.
Thank you, Chairperson. The next study that we'll be presenting is Illegal Initiation Schools in South Africa, assessing the risks to boys and young men. Within this 15 minutes, Chairperson, we will just quickly go to the aims and objectives of the study, which the study aims to explore the causal factors that lead to the establishment and persistence of illegal initiation schools, and to explore the measures that can be put in place to remedy the situation and to prevent the scourge and protect the lives of the young boys and men. I will then ask also Naledi to then come in chair for the interest of time to tell you more about our findings when we conducted this study, and then go straight into the recommendations so that we are able to capitalize for discussions. Over to you, Naledi. If we can then just go to the findings of the study, and then we can then discuss more in detail the recommendations thereof. Thank you, Chair.
Thank you very much, CEO. Given that there are time limitations, please allow me to just go through my notes and speak on key findings, because if I follow the presentation as it is, I will get lost. I had prepared to speak the committee through everything. But please allow me to just take us through key findings emanating from the research. So, Chairperson and honorable members, a number of key issues emerged from the findings presented and discussed in the report, and these are mainly clustered around key thematic areas. The first one being issues relating to the prevalence and location of initiation practices in the 4 selected provinces, factors contributing to the prevalence of initiation schools, methods of recruitment and operation, problems arising out of illegal initiation schools, and lastly, official interventions and responses to deal with these problems. In terms of the prevalence of illegal initiation schools, it seemed that there was no authoritative information, including reliable statistics that can be gathered on these illegal initiations. We stated, however, that this may be understandable given the illegal and therefore clandestine nature of these schools in South Africa. Many of these illegal operations are conducted secretly and with the purpose of avoiding detection, given the legal consequences for those who are involved. Therefore, law enforcement agencies are not able to gather sufficient and reliable information on the occurrence patterns and the scale of the prevalence of illegal initiation schools in the provinces that we looked into. Nonetheless, there is no doubt that both legal and illegal initiation schools do exist in the provinces that were covered in the study. However, as to whether there are more legal than illegal initiation schools or vice versa, it was difficult to determine given the lack of accurate and reliable information, particularly from SAPS. In some provinces, such as Gauteng and the Free State, there are clearly identifiable locations and residential areas in specific municipalities where such illegal initiation schools are likely to operate. In the Eastern Cape and Limpopo, the specific pattern of geographic locations and prevalence were not very much clear. It should be noted that illegal initiation schools are not based in permanent locations and structures and are thus highly mobile. This makes their activities and operations difficult to detect, subject them to normal oversight as well as monitoring requirements, particularly those that are conducted by local municipalities as well as departments. Excuse me. Also, we noted that such clandestine operations are difficult for law enforcement agencies to trace for the purposes of effecting arrests. In the case of legally operating initiation schools, their location and prevalence are relatively easy to determine and quantify, given that they are legally required to register and undergo fairly well-defined pre-qualification and selection procedures before they are allowed to operate. We noted that the data collected on legally registered initiations schools differs from province to province as well as from season to season. Some provinces and municipalities do collect and store valuable information on the legally registered ones, although the accuracy of such information as well as the figures appears largely unreliable at best. For instance, in provinces such as Gauteng and the Free State, there were strong allegations that were made that fraudulent registration papers were being issued by local municipalities, thus making it difficult to differentiate authentic and non-authentic registrations in terms of the initiation schools. In terms of factors contributing to the prevalence of these initiation schools in the study, what we noted, particularly from the key role players that we interviewed, many of those are officials as well as traditional leaders and those who oversee and partake in these processes. We learned that there are push factors as well as pull factors that create a situation wherein young men and boys attend illegal initiation schools. And for the purpose of the study, we said that push factors are those conditions and circumstances that compel the initiates, often against their voluntary will, to subject themselves to the practices of both legal and, most importantly for the study, illegal initiation schools, whereas pull factors are those factors that are attractive and are seen to be positive, or they are gains related with them in terms of the initiates being enrolled at these illegal initiation schools. One of the key push factors is peer group pressure, as the young boys and young men in some of the local communities that we engaged with, especially in the provinces that we visited, and we said even presumably to other parts of the country. They are part of social groups as well as youth networks, and these impact and shape their day-to-day behaviors as well as life experiences. And such social groups and networks do exert considerable force, which often entails pushing young men and boys towards illegal initiation schools. The second key push factor appears to be the lack of financial resources, especially for many young men and boys from impoverished families who may seem to be desperate to undergo initiation. It seemed from the interviews that we conducted in the study that to a very large extent, the lack of financial resources was a key factor pushing young men and boys to illegal initiation schools, implying that such schools may be more affordable. However, of course, there wasn't sufficient data for us to determine that indeed, in comparison, illegal schools are far much cheaper than the legal ones. Nonetheless, it was an issue, and that cost was indeed a push factor for a lot of the young men and boys. It would also appear that the fear of parental disapproval, especially for young men desperate to undergo initiation, acts as a push factor where admissions and qualifications in these schools are procedurally lax, and that there is no prior parental consent that is required, as opposed to legal initiation schools where parents must give consent for their children to partake in the procedures. In terms of pull factors, a number of common circumstances were identified, and these include, excuse me, respect for the cultural practice by both caregivers and their children, the idea of transitioning from boyhood to manhood, the promise of the benefits of being an adult, such as the ability to take a wife and being given adult responsibilities, and thus avoiding constant humiliation, as well as the disrespect and the name calling that comes with being called, being an uninitiated young man or boy in communities. So what we state in the report is that both pull and push factors are critical in driving young men towards illegal rather than legal initiation schools, and subjecting them to the attendant risks to their health as well as their social welfare and safety. Excuse me. There's a point that I'd like to make before I'm wrapping up and going into the recommendations, if I could just quickly find it. So it is in regards to the recruitment of initiatives, the recruitment of the initiates. There seemed to be a clear differentiation in terms of approaches used by legal as opposed to illegal initiation schools. Many of the informants that were interviewed clearly outlined the recruitment procedures that must be followed in legal initiation schools. And such procedures entailed involvement of various role players with clearly defined roles and responsibilities, such as the parents, legal guardians, as well as primary caregivers, the local chiefs, local authorities, as well as government departments. However, as it comes to illegal initiation schools, of course, the role players are not very much engaged. In fact, what we uncovered in the study is that a lot of the times the young men would actually be abducted and would be forced to partake in these processes. I also want to mention a key point around profiting. It seemed to be a key factor pushing those who were involved, the criminals and syndicates, to run these illegal initiation schools because of the fees that would be imposed onto the families or parents. And sometimes these would be extortions because they would say, in order for you to get your child back, you should pay such and such a fee. So this was one of the key areas that we uncovered, including the fact that in some instances, individuals would use gangs that already exist in the communities to force young men and boys to partake in these illegal initiation schools. There were a number of interventions mentioned that were being rolled out at the time. I must state, Chairperson and honorable members, that this study dates back to 2021 and predates the Customary Initiation Act. But there were a number of initiatives that were being undertaken. However, they were not very much effective in curtailing the challenges. I now want to go to the recommendations quickly. A lot of them touched on the...
You have 2 minutes for that. In terms of the original time, it's 2 minutes.
Thank you very much, Chair. There aren't a lot because a lot of them were in regards to the bill being adopted so that it could be used as a tool to address many of the challenges that exist. So the key recommendation was for the bill to be adopted as a legal act of law. But just in addition to that, we recommended that the South African Police Service at provincial levels, including municipal police, develop and strengthen their detective and intelligence gathering units to build capacity to combat the proliferation of illegal initiation schools, including the criminal activities such as the kidnappings and killings of initiates. We recommended clear national guidelines for strengthening vital services from provincial departments such as water and sanitation, Department of Health, social development, cooperative governance, and traditional affairs, so that they could coordinate their support and efforts in ensuring that services are brought closer, especially to legally registered schools. We recommended effective community and educational awareness programs that must be conducted by provincial houses of traditional leaders, and that they must work very closely with municipalities and other key role players, including parents, school principals, and teachers in communities affected by the problem of crime and antisocial consequences relating to illegal initiation schools. My time is up, Chair. Thank you very much for the opportunity to present.
Thank you very
Recording
much.
stopped.
Chairperson and commissioners, the Portfolio Committee has dedicated a huge amount of time to deal with these issues. I must say that your recommendations might be predating a lot of this, and so I would say more or less everything is aligned with our expectations and our observations, our findings, and our recommendations as well. And so I don't think we will have much of differences in terms of the approach. Obviously, there's a lot of work to be done going forward. Let me allow the members to make comments, and then we can then also get the department to comment. But I must say a lot of what you have raised, a lot of it has actually been given a lot of attention already. And so it's nice to look back and say, well, you were also on the right track. And so looking from where we are, a lot of things have actually been given attention. Honorable Van Zyl and Honorable Taiposh.
Thank you, Chairperson, and also again, thank you to the CGE for a very good report once again. I only have two questions, Chairperson. The first one is that, in the report, it was highlighted that there's corruption in municipalities issuing those fraudulent permits for initiation schools, especially in Free State. I wanted to know if the CGE has reported any of the officials to law enforcement bodies and what feedback, if there's any, has been received. I'm just interested on that. And then the second question really, I suppose would be an opinion, with the deaths and injuries that persists despite there being legislation. What is the CGE's assessment of why enforcement is failing, and what practical immediate actions must Cooperative and SUBs implement before the next initiation season to prevent further loss of life? Thank you, Chairperson.
Thank you, Honorable Van Zyl. Honorable Taiposh, followed by Mkhaliphi.
Thank you, Chair. Chair, mine is just a comment. I think, Chair, if we can make our report available to the Commission, there's actually a lot of things in there that we have covered that I didn't hear come through here. But just as a matter of interest, we've done a lot of work in terms of this very subject, and I think it would be well worth it for the Commission to see our report and our recommendations on this as well. Thank you.
Honorable Mkhaliphi. Thank you, Taiposh.
Thanks, Chairman. I just want to have one question from the CGE. The role of women on the initiative. Because there was a time whereby we met with the Traditional Council together with the Department of Traditional Affairs in the province of Eastern Cape. And I raised it sharply that the young initiates that are taken to go and practice this custom, if the women who are the mothers of these young boys are not on board from the beginning, what we want to achieve is the country not to have a single death after sebebuye entabeni. But if the women are sidelined, only they have a special place when the boys are coming from entabeni, and the role of the woman is also only ukugaya utshwala and prepare for the boy to come. We won't achieve what we want to achieve. So I just wanted to understand from the side of the commission, do you make sure, do you enforce the role of the women from the start up to the end of isiko labantwana? Thanks, Chair.
Thank you very much. Let me allow the commission to respond.
Thank you, Chairperson. Naledi, if you can tackle the technical questions, and then we can then close. Chairperson, what I can then highlight in as far as the first question around the role of the South African Police Service. So in our studies, very much highlighted that there is a collaboration that is happening between the South African Police Service as well as the House of Traditional Leaders in terms of opening up cases that relate to illegal initiation schools. So we do know that already that system is in place, and there's that collaboration. Whether that system is effective is another subject that we need to discuss, to say to what extent are we able to identify and meaningfully report these questions, and who bears these responsibilities this responsibility to report as and when such schools are being identified. Because from our report, it just simply says cases are being reported, but we keep on seeing some of the cases that are, or some of the mushroom illegal schools that are still coming up, notwithstanding that system. And then it says to us, perhaps maybe, Chair, we need to do more than what is currently in place because it's not really helping. And I'll be interested, Chair, I think from the CG side, to really get that report from the committee to see the work that has been done, because it will also give us a sense of new contemporary areas that you have dealt with and to what extent, so that we are able also to supplement and provide a close-up report in terms of our own intervention. Naledi, you can then come on others. Thank you. Thank you, Chair.
Thank you very much, CEO, and the honorable member for this question, which I also think is quite controversial on the role of women in these processes, particularly because traditionally, and this is what we were informed and what we've observed, is that women have no place in discussing issues of circumcision as well as initiation. So it did come up. In fact, we experienced it firsthand. One of the researchers in the study was a woman herself, and she felt very much sidelined and excluded during the discussions because culturally it was seen as a taboo for her to actually even be present and be posing some of the questions that she was. But I must say, of course, women are parents of these children, especially if children are underage, and therefore the consent that is required, of course, if the woman is the parent, then she should be involved, very largely so. And also because as South Africa, I mean, we have this issue of single women-headed households, families that are also headed by grandmothers who are the sole breadwinner or the key elder in the family. So, of course, from that point of view, their opinion, their role should be respected. And like I said, especially where permission must be given. But again, Honorable Member, this relates more to the formalized practices. The challenge here is that the report focused on illegal practices where there is no consideration at all for the law and for even their parents. And parents themselves being tormented by the gangsters who would threaten and demand money so that the young men or boys could be released. So it is a key, an interesting point that you make, but I do say it's quite controversial. And I think ties very closely with what members were even saying earlier around reviewing some of the cultural practices, especially where there are biases and discriminations that are unnecessary. So I would say that, of course, women have a key role to play, especially as parents. But further research might need to be conducted in terms of other areas where women could contribute. We've heard of interesting academic research around women, in fact, playing a very key role in these processes. It's just that, of course, a lot of it is hidden. Like I said, it's seen as a sacred practice where outsiders are usually not let into all the details. But we've seen that in the academic space, there's quite a number of areas where women are given a role. I think those should be explored further. But thank you very much for the interesting question.
I didn't hear you respond about laying charges. That was asked by the first member who raised the question.
Oh, okay. Yes, Chairperson. No, we did not lay charges because in the study, as researchers, when we engage with individuals, we do this in condition of trust that we first have to build. We go through a process of negotiating first with gatekeepers to say, please let us in and give us as much as possible. And for us, if we lay charges, it would mean that we won't get participants coming in to share their insights as well as experiences and views with us. So first, it's quite key for us as researchers to build that trust with communities, for them to be able to let us into what is actually happening. So again, because in research, we treat participants as experts, it differs from how in the law they would be looked at. So these allegations for us, we treat them as their truth, but we do not interrogate and do not find whether there are, legal issues wherein now we must go and report cases, etc. We don't see the findings rather in the first instance as cases, but rather as lived experiences and data that we can use so that we make recommendations that would then allow for these practices to be better handled. But again, we did not. I think
that's satisfactory for now. I think we can. I just wanted you to react to it, but I think that's fine. I can see your direction. That's fine. Chairperson, do you want to make any comment?
Just, Chair, in the interest of time, just to say we would also like to work with the committee because you have got a bigger footprint as public representatives chosen by the people to actually go to these communities with yourselves, the same communities that have chosen you, and we have access to actually tell them about the impact of some of the things that are happening there and empower people in terms of laying charges, approach duty bearers such as SAPs and all of that. But I think it carries weight to go into the communities as a second time around now to say violations have happened. Let us work together when we are with you because you are the authentic leaders. Thank you.
Thank you very much, Commissioners. Let me say that, as I said to you, your research came much earlier. A lot of things have happened since then. There's been a legislation on customary initiation, which has largely provided for two kinds of structures. One oversight structure, which is called NEOC, which is an oversight committee, involves a lot of leadership structures, traditional houses of traditional leaders. It involves the CRL and others to oversee the whole process of initiation. And then there's another technical structure, which is government coordination, which is the PICC. And again, here it's bringing all the departments that are supposed to work together and in the different spheres of government to oversee this process. That is already being implemented. When the committee got involved, we were concerned that there was the legislation, but the numbers had not started showing any decline. And so a lot of work was gone into. Amongst the issues that we have been really looking at is that there are provisions in the bill for proper administrative registration of initiates, proper involvement of parents with concerns, proper medical certification of indication of the health status of the initiates, and insistence on the age restriction in terms of where all the what age the youth should be, and of course that all of these must be registered and be known by the local leadership, particularly traditional leaders. We still find a lot of people who are still falling out of that, and therefore there's been a strong intervention where these PICCs and New York have gone in and actually closed down a number of these schools and have proceeded to ensure that these people are prosecuted. What we found, obviously, has been the delay. The limitation is that this custom is not driven by officials or traditional leaders directly. It's families, it's parents, and so at the level of the choice of surgeons and nurses, traditional nurses and surgeons, parental involvement and their role is such that when there's an accident happening, those are the ones who collude to reduce the ability of the criminal justice system to get the correct information and, in fact, prosecute some of the people. That is what causes the limitation in terms of numbers of people who are ultimately convicted. So I've gone through all of this and the need for coordination of the various departments, the need for a very strong community education program that will help people to learn new things and unlearn old practices, and also reduce the stigma associated with the culture of silence and people not participating and not collaborating with the criminal justice system. I want to just give those as highlights because that's what, if we share the report, it will highlight those kinds of issues. But I want to say that the work that we have done has really been very helpful, but we take the fact that there's a while back and what is happening now, we still haven't gotten rid of the problem, but there's a lot more hope that we can get there. But we've seen this, it requires us changing the mindset of society to deal with it. I hope that the team, the Secretariat could share some of that report with you so that you might be aware of where we are, and then of course participate as we continue to monitor, because I think your monitoring also will still be very welcome in this kind of situation. Let me hold it at that and ask that the DG and then the Deputy Minister of Traditional Affairs should come in and as we round up this subject. DG? I haven't seen the DG on the platform. Is DG here? Oh, yes, you are. Welcome, DG. After you shall be the Deputy Minister. Thank you very much. Proceed.
Thank you very much, Honorable Chairperson of the committee and the honorable members of the Portfolio Committee. Greetings as well to the Honorable Deputy Minister, as well as the Chairperson of CGE, the CEO, Mena Lady, the researcher, was presenting, and other colleagues on the platform. Chairperson, I think we agree with the summary as provided. This is a 2021 report, so it indeed predates a lot of the work that was done. The Customary Initiation Act was still a bill at the time. It's since been passed into law, and the first recommendation of the Commission is that the processes of promulgation of the Act be fast-tracked, so that has been done. And it has established those structures that the Chairperson has referred to. And there has also been further work in some of the directives and regulations that need to be put into place, emanating from the Customary Initiation Act itself. So, for example, Mena Lady talks about the issue of the risk of commercialization. As we reported to the Portfolio Committee before, one of the focal areas we've had was to work on proposed regulations on the fees and the possible standardization. So there is work that has been done in that area, and I'm just giving that as an example. And of course, in those structures, such as New York, as the chairperson has indicated, we've got the CL Rights Commission represented, we've got SAPS represented, we've got health represented, we've got NPA represented. Yes, the problem is still with us, but there is indeed a lot of work that has been done to take this work forward. So, Chairperson, I think what we may offer as well as the committee will be sharing its report is perhaps also to offer to have an audience with the commission so that we can share with them the work that has been done since, but also we welcome their partnership and their continued support and oversight in this area, because it will take more hands to make sure that we deal with the problem as we face it. But we will offer to then have an audience with the commission to take the discussion further based on the findings and recommendations they've made. Thank you very much, Honourable Chair.
Thank you, DG. May I invite the Honourable Deputy Minister, Leaji, please come in.
Thanks very much, Mavov, the Chairperson, Honourable Members, Chairperson of the Commission, and the entire team, DG, and the entire team of COCTA. Well, let me start with the first presentation, Mavovo, which talks to issues of land. Although I joined the meeting in the middle towards the end, but at least I did manage to pick up some insights of the report. And I would agree that we probably need to have a further conversation with the Commission, especially to broaden the understanding in terms of the current in communal areas. If I can just share some insights. In communal areas, there is no household that has a de jure ownership of land as an asset. Communities occupy, they have what we call de facto occupational right, which is something that could be traced to colonial paternalistic architecture of land ownership patterns. As a result, the current bill, which is being proposed by the Department of Land Reform and Rural Development, in line with the provisions of Section 25, subsection 6, read together with subsection 9 of the Constitution, seeks to bring those kind of redress necessities. So that kind of context becomes key when an analysis is made. That's one element. The second element is that indeed, when it comes to the issue of ownership, more often, Mavovo, I hear probably even commissioners, they can make that mistake. Members of Parliament, including some of us in the National Executive of Government, when we refer to the issue of land ownership, it's not something unusual to hear senior government functionaries or officials making assertions that, for instance, traditional leaders are the owners of land, which is not correct. Traditional leaders are custodians, not the owners. And by being custodians, it means they exercise protective care of the asset, over the asset, on behalf of the communities. The owners of the land are actually the communities of whom traditional leaders are an integral part. And by virtue of the aura of the lineage of that traditional system, they would name themselves or the land after that traditional lineage. So it's not owned as a PTY Ltd by a traditional leader. In fact, even administration thereof, it's not by a traditional leader, a single entity or incumbent. It's a traditional leader in council. So these are some of the distortions that we need to look at and make sure that we correct, because I know that there are a number of traditional leaders who, when it is said like that, they just take it as it is. And assume a posture of being the owners of land as PTY Ltd. So even, the power of language is very critical. When you make pronouncements, you must really think very carefully in how you craft any particular assertion. So those are some of the challenges, Mavovo, we come across. And we always, we don't tire, of course. We always try to make sure that those explanations are given. So thirdly, on this issue, it's important to make sure that the Gender Commission works very close with the houses of traditional leaders. Because it is not acceptable where you have either widows or women in their own right cannot own land. It's a misnomer. It's never there. If it is done, it means it's wrong. These are the things that we need to collectively work around, correct them. And of course, bringing along the relevant department, which is your land reform, as well as right development. Coming to the issue of the initiation, I think your summary, Mavovo, was spot on. Some of the things that I wanted to check from the CEO, I don't know whether it's the CEO who was presenting. One of the probably assertions that she made was that this researchers could not get some of the information. I would be interested, just as a researcher in my own right as well. Those who were conducting the research, were they themselves part of what they were researching? Because sometimes, when you employ, whether it's the kind of ethnography, if I can put it that way, the kind of ethnography that you use is such that it makes it much more easier if you are also part of the tradition that you are investigating. Because, for instance, if you will conduct investigation about initiation, you have not been part of the initiation schools, it will be seen as an intruder. You will be seen as being disrespecting what is culturally guaranteed, because also culture is there in the Constitution. So we also have to be sensitive in terms of those that we deploy to conduct research and so on, whether they also are in a position to access certain information by virtue of them being, there is what we call a certificate of fitness. If do they have the certificate of fitness? And the last issue that I wanted to talk to Mavovo is the issue around the role of women. I normally hear that women are sidelined, they don't participate. I don't know, cultural practices, they differ from one area to another. But what is common is that it starts with the family. It starts with the family. And more often, young boys, the first person that they will tell that they are now ready, they will tell the mother. and the mother will come to the father. Then the father will bring, it's the system that is there. And throughout that process, women have a very clear role in terms of the initiation process, including being briefed by the health of their children, by the fathers who are always there or uncles who are always there. So some of the challenges we see today, Mavovo, arise out of disintegration of social institutions, which is a societal matter, societal challenge. I will make an example. I went to Limpopo. I'm a Xhosa by ethnicity, if you can put it that way, but I was accepted to visiting initiation schools to the point of doing everything and anything that I was supposed to do as a man who has undergone the same practice. It was not difficult for them to accept me. So, and everything, it went well. I made my own observations, comments in terms of what needs to be improved. One of those, for instance, the age. What the Constitution says, because the Constitution, in terms of Section 28, children, anyone below the age of 18 is a child. But how do we deal with that? So those are the things that we would have to look at, Mavovo. Again, I went to Mdantsane. In Mdantsane, Mavovo, a very painful situation. A young initiate, you could see that this young initiate, if we were not there for the, we would be talking a statistic today. And the reason why, he was not given water. And when I asked, why are you not, where is the traditional caregiver? He came. Why are you not giving the initiate water? No, it's because the father said I must not give this child water. Just imagine a father giving such an instruction. So these are some of the practical challenges that we come across. And therefore, a collaboration in dealing with these matters through the established institutions, as you correctly put it, Mavovo, your New York, your PICC, and so on. We would really want to see a more visible and collaboration from the Commission side. Input will be valuable, and I would really appreciate having a session with them so that we can have a more comprehensive and focused kind of engagement on both matters, the land as well as initiation, and any other study that we think, whether it's a Traditional Courts Act and so on. So we are very much willing to work together with them to bring solutions to the challenges that are facing South Africans. Thanks very much once again, Chair.
Thank you very much, Honorable Deputy Minister. Certainly, I think you have made your case for an appointment with the Commission for Gender Equality. I'm sure you will take this up in your own private communication so that you can clear a number of these issues. Some of those issues that you believe the Commission needs to consult with the National House of Traditional and Khoisan Leaders, I do see a role for you as the executive to actually clarify and deal with a number of them, because implementation of some of those policies falls within the ambit of the executive in the name of the Department of Cooperative Governance and Traditional Affairs. But thank you very much for your comments. Thank you very much to the whole Commission for Gender Equality. Very interesting information and very good engagements. We really appreciate. Please keep up the good work, and we will always be in touch as we deal with these issues, because all of this is work that's going to be, ongoing. So you will always find us as ready partners with you in taking forward the issue of the rights of our people on all the issues that you are looking at. So thank you very much. You may at this point be excused. Honorable members.
Thank you.
Thank you. Honorable members, I want to beg for your indulgence, a slight amendment on the program. We're going to move to the Commission for Religious and Linguistic Communities, CRL, to do their presentation, and we will deal with the update a bit later. I think the Commission, they've already joined. So from that point of view, I would like to invite the chairperson of the CRL as well as all the members to show their faces as we introduce them into the committee. Let me say the purpose of this discussion is for the CRL to give us a briefing on their activities. And we have, as we're discussing the issue of the budget review, touched on the history of some of the work that they were doing that relates to their previous presentation to the COCTA committee. I must say that we do have now that report that was tabled to Parliament on your last interaction, and I hope it has been shared so everyone has it, but I know the members do have that report. And certainly we did raise with you the comments, the questions of the letters, memos or memorandums that were sent to the President, Minister, and to the committee, that there has been certain concerns raised. I may as well say that last week I was actually invited to collect a memorandum on behalf of the Speaker of Parliament on the same matters. So I'd like to propose we approach this matter this way. Firstly, you shall introduce your team and let's see who is in the CRL. Secondly, you will take us through what you do as a commission. Thirdly, you will also reflect on the previous engagement and the history of the work that you are doing now, based on the fact that there is a portfolio committee report that went to Parliament, and then you can then comment on the issue of the memorandum that was sent to us. We probably, depending on how you table this matter, might need another engagement on that subject. But for now, I think we just want to know, what is CRL doing? Where does this come from? How are you approaching it? Are you aware of these comments? How are you dealing with them? And all of that. But primarily, what is the CRL's focus? And primarily, the issues of the Section 22 committee, all that background. You can then at the end deal with the comments on the memorandum. So I don't want you to spend time dealing with the memorandum before you take us through this whole other background information. Please go ahead, introduce your team. You will have 40 minutes to take us through all of this, and then we'll have engagement after that. Honorable Togo Mkwana and your team, you are on the floor.
Thank you, Honorable Chairperson. We are having an electricity challenge. I hope you can see us as much as we
Once you have introduced your team, you can switch off. At least we can see the two of you. But if you want others to show, let them show their faces. After that, you can switch off and then continue speaking.
Okay, thanks a lot, Honorable Chairperson. Honorable Chair and members, with me, I'm Togo Mkwana, the Chairperson of the CRL Rights Commission. On my left, we're sharing the screen, is Prince Mahlangu, the Deputy Chairperson. We're also joined by our communications person, Biake Mkolo. Our CEO will be joining us shortly.
he is stuck somewhere. So we'll continue with just the two of us. We are going to do a slide presentation so that we can move easily and quickly and be able to do all that we need to do. So we'll start by the broad situation, as you said, Honorable Chair, and then we'll go to the ad hoc Section 22 committee, and then we'll go to the memorandum at the end and the other letters. We're going to ask that they help us share the screen. We'll be switching off the video now. May I check, Honorable Chair, whether you can see the slides we're sharing?
Yes, it's visible. Proceed.
Okay. Thanks a lot, Chairperson, honorable members. We'll do a quick run so that we cover
just a little bit. Sorry, Ms. Mkona Zikaluva.
Yes.
We don't seem to have those slides. Have you shared them with our secretariat?
Yes, we're sending them now.
Okay, ordinarily.
We're sharing on the screen.
Ordinarily, the slides come the day before or 2 days before, so that we go through them before we get here. We don't spring them on the committee in the meeting. So in future, please make sure you submit beforehand, at least 2 or 3 days before, so that we can proceed. Now, before you continue, let me ask that you share them with the committee, and then we must send them to the committee. Then we can proceed when the committee can follow what is happening. It's going to be a bit unfair to run through the slides on the screen, and they've not seen them, and they don't even have a copy. So we'll wait a little bit to see that you send them through. Honorable members, my apologies. We will want to circulate the slides so that as the processes continue, you have the copy. I'll just wait to see if the slides have been received. Just give me a few seconds before you can proceed.
We apologize for this, Honorable Chair, honorable members. We are sharing the slides now, and we'll send
you
them.
You will only proceed once we have received them. Please wait. So send the slides through. I've not seen them.
Okay.
Janine, just send the presentation to you.
Accept. We will wait to hear from you, Honorable Chair.
No, we have not received. We have not received. Sorry, Chairperson, we have not received them. We'll wait until we receive them before we can proceed.
Okay. Okay. Thanks a lot.
Chairperson, somebody needs to send this to Shireen. We have still not received it. Somebody needs to send it. We still haven't received it. So.
Sorry, Honorable Chair. Shireen has confirmed receiving the slides.
Okay, honourable members, the slides are available, so we can proceed. Chairperson, please proceed. You will have 30 minutes through the presentation, and then we'll start the engagements thereafter.
Honorable Chair, pardon us for that misunderstanding. Can you see the slides now that we're sharing?
Yes, proceed. The slides are visible now. We've got also received the copy, so we can proceed.
Okay, thanks a lot, Honorable Chair. Basically, what we're saying is that there were challenges faced by the Christian sector in South Africa of financial, spiritual, sexual, emotional, and human dignity rights abuses. We then, as the CRL Rights Commission, decided when members of the communities started asking the CRL about its role of protecting the religious community. In response to this, we then had what we call an investigative study to investigate what was happening in the country at the time. In 2017, towards the end of the year, we presented to the Portfolio Committee our recommendations. These recommendations included the need to protect religious freedom without attempting to regulate it from the side of the state. However, as specific practices in the religious community infringed on constitutional rights of congregants and violated existing legislation, we recommended that the religious communities should regulate themselves more diligently to be in line with the Constitution and the law. The Constitution leaves scope for all kinds of beliefs and opinions. Even views which some may regard as extreme are allowed and should not be regulated. If you want to worship a tree, you are free to do that in this country. The religious leaders should exercise their religious freedom with due regard to their legal, ethical, and community responsibilities. And then after our presentation to Parliament, the COCTA Portfolio Committee then had views from the religious sector. In the report of the COCTA Portfolio Committee, there's a long list of other people who presented after the CRL Commission. It was about a week or so. And the Portfolio Committee came up with these recommendations on 14 February 2018. The committee notes that across the sector, there's agreement that there's abuse in the religious sector and thus recommends the following: that there be a national consultative conference, including the linguistic and cultural communities, that should be convened to give a platform to discuss challenges in the religious sector. Arising from the NCC, the following should be established: a charter for self-regulation, a code of conduct for the sector, which should be recognized by legislation. And it continued, the recommendations continued. that there must be a strengthening of the mandate of ICASA and other such bodies to penalize misleading media claims, and that the legislation should be strengthened for the NPO Act and the Income Tax Act to ensure registration of religious institutions. Between 2018 to 2019, a national consultative conference was held in February 2019. A meeting of religious leaders was convened, and at that meeting, a task team of religious leaders was established to take the portfolio committee recommendations forward. The task team of these religious leaders did not have a secretariat and the budget to consult communities throughout the country. And when this current CRL commission was appointed with effect from the 1st of January 2025, we then, at our inaugural strategic planning session, resolved unanimously to facilitate the implementation of the 2018 COCTA Portfolio Committee. And a resolution was taken at the Sarah Rights Commission plenary to go ahead and establish religion-specific ad hoc Section 22 committees. The first would be for Christians, followed by Muslims, then African traditional religion, Rastafari, Baha'i, etc. The Section 22 of the Sarah Rights Act, it says, we may establish one or more committees consisting of members only, or members and staff, or other persons who are neither members or staff, to assist the Commission in the performance of its functions, and that these committees can be dissolved at any time, since it's this one in particular, it's ad hoc. And Section 22 says we must determine the functions, terms of reference. We must appoint a member of a committee as the chairperson of the committee. We may remove a member of a committee at any time and may determine a committee's procedure. Here are the terms of reference. I'll go a bit slowly because they are at the core of everything. The committee shall conduct consultations with Christian communities and organizations throughout the country about the development of the legislative framework to provide for the establishment of a charter for self-regulation and a code of conduct supported by legislation. This comes directly from the COCTA Portfolio Committee recommendations. We then came up with members. We'll run through this list of who are the committee members, because some of the questions and the concerns in the letters refer to that. So we thought, let's give this view. Reverend Gif Morane is the Council of African Independent Churches, is the president of what in other areas are known as Amazayoni, in other areas as Abaprofeti. You would find them worshipping next to the rivers usually. There are about 8 million people throughout the country. And then the Nazareth Baptist Church, which consists of about 6.7 million people. Reverend Matenjo from the Tembezinhle Nazareth Baptist Church is a member. Inkosi Pagama from the Gauteng Nazareth Baptist Church, and Mr. Lizingwane, who's the Secretary General of Ebuhleni Nazareth Baptist Church, is also a member. Reverend Samboti of the Guinea Nazareth Baptist Church is a member. Dr. John Maloma of the Evangelical Alliance of South Africa is a board member, and they've got 4 million people. This is what is known as TIASA for short. Mr. Seth Mazibugo is representing the Moral Regeneration Movement, is the COO of the MRM. Pastor Joshua Macaulay is the leader of Rhema Bible Church. We have been working with them throughout the years as the Civil Rights Commission. Mr. Pete Likhanyane, who's the chairperson, and Reverend Prince Decker, the Secretary General of St. Agnes Zion Christian Church, are also members. Professor Temba Musia of the Zion Christian Church was appointed by His Grace. He's an academic who's a member of the ZCC Church. With together, the St. Agnes and ZCC, they have about 11 million people, Christian members. And then Reverend Oscar Madlala is there representing the South African Council of Churches. He's an NEC member, and the South African Council of Churches has a membership of 16 million. And then Professor Mustakulu is an academic and a pastor, is the chairperson of this particular committee on Christians. The membership representation, which will make sense as we move on, all in all, the people who are members represent about 45 million Christians in the country. According to Stats SA, there are 52.8 million Christians in the country. This means that 86.6% of Christians have agreed to be part of the Section 22 committee, which shall consult the Christian community towards the development of a charter for self-regulation, a code of conduct for the sector, which shall be recognized by legislation. And this group of people have all committed to run with this on their own. Would like to stress that the commissioners of the CRL Commission are not part of the Section 22 committee. It's mainly the Christians who are represented that we've just gone through. The only thing that will happen is that the secretariat will be formed by staff members of the commission and not commissioners. Then there were letters of concern that were sent to us for us to respond to. One of the accusations is that we have handpicked Section 22 committee members. After extensive engagements with the executive committees of identified Christian umbrella organizations and the big churches, the mega churches, the said organizations then appointed their representatives. There's a gender issue that has also been raised. The executive committees of churches and umbrella organizations that we met with were mainly males, and the appointed representatives are males. However, we're currently working towards co-opting women from religious fraternals that are in all 9 provinces. So we're working on bringing them in that particular way. Another issue is people said they were not being informed about the date of the Section 22 launch. This was publicized in the media and it was always on our social media platforms. That people were not invited to join the Section 22 committee launch. This was a small launch of 250 people and not everyone could be accommodated. This launch was live streamed by the media and our social media platforms so that everyone could have access. Maybe I should note that even His Grace attended the launch of the Section 22 committee. And then one of the letters talks to meeting with Mrs. Mkhwana Skaluva on the 21 May 2025 to raise objections to her renewed pursuit of state regulation. The CRR's response to that is that the meeting with Freedom of Religion South Africa was on the 21 May 2025. It was with the Sarah Rights Commission and not with an individual. Its executives attended, including the deputy chair and the staff members. Section 22 peer review committee chaired by Professor Musakulu is ultra vires. The Section 22 committee on Christians is not a peer review committee. It's based on the recommendations of the portfolio committee. Another issue was Section 22 committee singles out Christian faith as subject of investigation. As we said earlier, the resolutions of plenary was that we'll start with Christians and then we'll go to Muslims, African religion, etc., etc. We've already started with the Muslim community. The Sarah Rights Commission model for peer review has been declined by the portfolio committee. We are implementing the COCTA Portfolio Committee 2018 recommendations and not the Sarah Rights Commission model of peer review. The COCTA Portfolio Committee recommendations lapsed with the end of Parliament in 2018 and have no binding legal effect on the Sarah Rights Commission. The recommendations made by the COCTA Portfolio Committee were for the entire religious sector. After the consultations, the religious sector shall go to report back to Parliament. And then the issue of the memorandum, we'll quickly run through the memorandum, Honorable Chair, Honorable Members. Protection of religious freedom. The Sarah Rights Commission's position on this matter is covered above, and we're very strong on protecting religious freedom. Affirmation of the Constitution, were for the Constitution, Section 15 and 31, and the Bill of Rights of the Constitution of the Republic. As a Chapter 9 institution, were duty-bound and constitutionally bound to respect the Constitution. It's not an option. A transparent consultation process. The Section 22 Committee Terms of Reference stipulates that consultations shall be openly done with all Christian communities and organizations in all 9 provinces throughout the country. The Sarah Rights Commission should desist from pursuing state-controlled peer review systems. The Sarah Rights Commission is simply implementing the recommendations which came from the 2018 COCTA Portfolio Committee, and there's no state-controlled peer review systems in the recommendations of the Portfolio Committee. Accusations of derogatory, divisive, disrespectful, blasphemous, infamatory, and insulting statements leveled against the chairperson of the Sarah Rights Commission. We are saying we know nothing about those derogatory, divisive, etc. statements by the chairperson of the Sarah Rights Commission, and we therefore distance ourselves from such accusations. What we've discovered, Honorable Chair, Honorable Members, is that there's a serious disinformation campaign that is running on social media. We are at a stage where we realize it is very hard for us to deal with the disinformation campaign that is deliberate and is targeted at the Sarah Rights Commission. I will give you a few examples of that. There was a cropped video clip that came from the interview that I had way back, I think it was 2017, during the Omotoso case, which was addressing what had been evidence-led when one victim, Cheryl Zondi, had been giving evidence about how they were told that God said they must sleep with him. And my response to all those issues of saying God said this, God said that, when people are actually misleading and abusing people, was clearly that if they are hearing voices, that couldn't be God talking to them, asking them to sleep with young people at 14, children at 14 years old. It couldn't have been God, it could have been some other illness. So they cropped that and took that part and they used that as their campaigning tool, deliberately disinforming people. The deliberate targeting of the CRL chairperson as the only decision maker when there are 12 commissioners who take decisions as a collective. The CRL aims to regulate religion. We have said it over and over that we have no intention of regulating religion. Neither are we aware of the state trying to regulate religion or a political parties trying to regulate religion. There can be no regulation of religion. We've always been saying it's self-regulation by the church itself in this instance. CRL intends to control church doctrine. We're not even involved in these consultation processes, so we cannot control church doctrine because that's at another level where it would be unconstitutional to do that. The CRL plans to introduce state religion. There's accusations that there's going to be a state religion, one religion in the whole country by 2030. We don't know anything about that. And I don't think in any other circles anyone knows about that state religion issue that is circulating on social media. CRL is facilitating state control of religion. We have said over and over, this is not what we're doing. It's the religious sector itself that must self-regulate and sort its own problems on its own, as decided on by the Cooperative Portfolio Committee. The CRL is facilitating state control of religion. It's not true. CRL is determined to take away the freedom of religion. We have no intention of doing that. The CRL only targets Christians and the church and not other religions. We have explained, Honorable Chairperson, honorable members, that we are currently looking at the Muslim faith, and we've already started a process around that issue to prove that it's not what we want to do. Thanks a lot, Honorable Chair.
Thank you very much, Honorable Member, Chairperson of the CRL. Honorable members, I've been struggling to find a way to tease out the issue of our focus with more priority so that we first clear certain issues and then deal with the controversy. Now, somehow I see the members have got their hands up. Somehow I would have loved us to focus on the report that was shared with us from the previous engagement with the portfolio committee and reflect on that before we can deal with what to me might appear to be, at the very least, a misunderstanding that comes in as contained in the memorandum, so that we know where do we start with our attention. Let me, because I see the members are already keen to deal with the issue, and you have seen that report, let me allow the members to comment or ask questions, then we'll see whether we are able to proceed in that direction. Honorable Van Zyl first.
Thank you, Chairperson. Thank you. Chairperson, there's a very clear and worrying disconnect between what the CRL claims publicly and what the CRL is actually trying to build behind the language they are using in this presentation. What you say is that you respect the Constitution, that you do not want to regulate religion, and that nothing you propose would interfere with freedom of belief. But what you want to do in practical terms tells another story. And this is from your own presentation. You want a national oversight framework for religion, a CRL designed peer review structure, governance standards imposed on churches, a national database of religious leaders, expanded investigative authority, and new legislation to give the CRL enforcement powers. Chairperson, that is regulation of religion, just through a softer door. So I must ask directly, how can you claim that you are not regulating religion when every element of your proposal centralizes oversight, creates compliance structures, and requires religious leaders to be part of CRL-recognized systems? You say it is self-regulation, but the CRL designs the structures, approves the councils, and sets the standards. That's not self-regulation, that's CRL regulation. You say you respect the Constitution, but the outcomes of your framework, the oversight, compliance, and central control, all point to state intrusion into faith communities. This is not harmless coordination. It's a push towards state-directed religious compliance model. And why this is a problem is it undermines Section 15, which is the freedom of religion. It violates Section 18, which is the freedom of association, and it threatens Section 31, the right of communities to run their own institutions. And it contradicts Parliament's previous stance, which is the document that the chairperson is talking about, which rejected regulation and insisted on voluntary self-regulation. So are we witnessing a constitutional protection or an attempt to introduce a rejected regulatory agenda under a new label? Chair, I also need the chairperson of the CRL to tell us what her source is to say 45 million Christians are represented by these bodies. I think this is very much overstated, and to mislead Parliament is an offence. So I'd like her to tell us the source and to provide us with those source documents. Chairperson, I have to say that we will oppose, as the DA, any indirect attempt to regulate religion through CRL structures. Thank you.
Yes, before we go in, I would also like to get the members, because that's why I've been struggling on the way we're going to approach this. There are two things here. One is, what was the source of the problems that was being addressed? And the question I'm trying to get is whether do we have a proposal of how those issues of abuse should be rather dealt with as opposed to what the CRL is doing. If we can keep the discussion with those two, because it makes it easier to us as we move forward in terms of we can see these are the challenges, this is what we think needs to be done, we can see this approach, we don't think this is what should be done because of the point that you are raising. Is it possible to balance it from that point so that when we move on, we don't have to come back to the same question? I'll just give you 1 or 2 minutes, Fansel, if you want to reflect on that.
No, Chairperson, I think I'll wait for the other comments before we do that. Thank you.
Okay. Look, honorable members, I would like you to try and keep, there are 2 issues to address here. In fact, there are 3, but I'll leave the third one because it's a minor part. There are 2 issues here. The origin of the problem was the issues of abuse, ingestion of fuel, grass, rodents, and all of that. And, some of the issues that relate to exploitative behavior, some of the issues that ended up in court. That's one group of issues. So I would like members to look at this is how we would think it should be, this matter should be approached, and then comment on what the CRL is doing, why you think this should or should not be the way. So I think if we can just keep it like that, it's going to help us as we move on. Honorable Mkalipi?
No, thanks very much, Chairperson. And I agree with you that we must find an approach on this matter because it's very controversial. One, the presentation that we just received from the chair of the commission, she is saying that it was a recommendation from the Portfolio Committee of COCTA in 2018. So the recommendation from COCTA was supposed to be processed and become the parliamentary decision. And I believe that there's a letter that clarifies from the Speaker's office that the report, which includes the recommendation that she keeps on referring to on the presentation, was not processed by Parliament. That's where we must start, Chairperson, to say you are not dealing with the report from Parliament. It was deliberated in the Portfolio Committee of COCTA in 2018, but when it comes to the House, to become the decision of the House, it didn't happen because the report was part and parcel of the items on the last day in 2018 to be adopted by the House. So there's a letter that is from the Speaker that also elaborates on that one to say the item is still pending on the agenda of Parliament. That is number one. Number two, firstly, when we deliberated about this matter, because there's a section of Christians, I believe, that they are the one who are taking this matter up, who are fighting this matter, saying they are sidelined. As a result, they don't recognize Section 22 committee. They are saying that it was constituted illegally, of which that where we come in last time we discussed this matter to say we need a clarity if Section 22 that was processed by the Commission was done legally or not legally. So therefore, you are saying when you open the meeting, you also went and fetch or get the memorandum from those section of Christianity or Christians, people who were marching recently, I think on the 13th of November. So I think in order for the committee not to take side, just to get a way forward on this matter, we must also invite those people who marched to Parliament to raise some of the serious concerns, which begs to come to the committee now to get a clarity if Section 22 committee indeed is legal or not legal. So I think if you are going to engage with the Commission without the presentation or the people who are presenting the people who marched and the chair went and fetched the memorandum, it won't be possible because we ended up not knowing what we are discussing, Chair. I remember this issue when I was very fairly new in the committee early in 2019 or late in 2019. There was a summit that we called as a portfolio committee in old assembly in Parliament, whereby we said each and every person who is part and parcel, who is as well concerned about what is happening in the country, including the petrol, who was fed the Congress, cockroaches, said, how are we going to deal with this matter? Because to us as Parliament, as members of Parliament, was to say, how do we stop this madness that is taking place in the country? And it's us as members of the Portfolio Committee who put pressure in the Commission to say you can't be a Commission, exist under Act of Parliament, and you don't do anything what is happening in the country, whereby a person will just call himself or herself as umfundisi of a certain church and said to a poor South Africans, in order for you to be healed or to become rich or whatsoever reason that brings you to church, you must drink petrol. It's us who make those noise. But now there seems as if as a way forward to deal with such matters, there is a confusion. So therefore, let us establish if indeed the recommendations that the chair is talking about is the recommendation that comes from Parliament. If it's not as a result of Parliament's report, let us clarify that one and take that issue out of the way, Chair. And then as a way forward again, and to say, as the Portfolio Committee, how are we going to deal with such matters, including the memorandum that was as a result of the march that took place recently, Chair. I think if you separate matters like that, we can have a way forward and a clarity, Chair. Thanks.
No, thank you. I just want the members to just hold on. I'm going to come back and allow you to comment. I said from the start, I've been struggling with the approach to the matter. And the reason for it is that there are three issues which we have to try and sequence in time and context. And those issues require that this committee must be very steady in the way we handle the matter. The first one is that there was a lot of abuse that was reported. It was in the media. Chairperson referred to the Omotoso case where there were women who were abused. There were instances where children were kept away from school. There were people who were forced to eat rodents, rats and cockroaches, others to drink fuel and all of that. Now, clearly a lot of this was abuse. The question was, what are you doing about that? Now, certainly this committee or the committee on COCTA had to find a solution to those issues. That includes a whole lot of other issues of abuse and exploitation in terms of money and all of those issues that are alleged there, non-registration, non-compliance, and what have you. So that was one group of issues. The second group of issues becomes the CRL's approach. Is the CRL approach correct? Is it needing to be amended? Does it need to be changed or stopped or whatever? That's a second group of issues. The third group are the objections of those who have raised a memorandum. Now, my struggling with the contextualization of this in terms of time is actually that we're trying to take over something that was done by the previous committee. So if I can just refer the members to two sections of this report so that we can be guided as we discuss. The item 3, if you look at the report from the previous portfolio committee, it raises a whole lot of issues in relation to the concerns that have been seen in the process of doing this study. But then the committee observations is where I'd like us just to focus, might help as well. Committee, and I'm reading through this now, this is on item 4 of the report of the portfolio committee that is being attached. The committee noted that most of the organization raised the following issues. One, the commission did not do sufficient public participation as only 85 denominations was invited in the hearings. 2, there was disagreement over the constitutionality of recommendations of the CRL. 3, religion should not be commercialized. 4, denominations have been self-regulated and these have been working well for them. 5, the commercialization is an infringement of the constitutional right of our people. The CRL Commission is not the body that should be regulating the sector. So that comes from that report. The next issue is the recommendation. The committee notes that across the sector, there's agreement that there is abuse in the religious sector and thus recommends the following. 1, a national consultative conference, including the linguistic and cultural communities, should be convened to give a platform to discuss challenges in the religious sector. Now, there is one concrete recommendation. Problem with it, it doesn't say by who, which puts us in a situation where who should we ask whether they've done this or not? Okay, that's the one recommendation, National Consultative Conference. 2, arising from the National Consultative Conference, the following should be established. 1 is a charter for self-regulation. 2 is a code of conduct for the sector which should be recognized by legislation. Then the next one is the strengthening the mandate of Independent Communications Authority and other such bodies to penalize misleading media claims. I assume that those would be claims linked to the pronouncement of religious leaders, as you will see if you go back to the report above. Then strengthening, the last one is strengthening legislation like Non-Profit Organization Act and Income Tax Act to ensure registration of religious institutions. This again refers to many churches that are not compliant in terms of these two legislation. So those were the recommendations on record that we have. Okay. Then, of course, the conclusion is that the committee noted the report of the CRL Rights Commission and would like to commend all that participated in the process. The committee made recommendations to the report and tabled it to the National Assembly for consideration. Now, we will need to decide as this committee whether we will work on the basis of this report or whether we will have to start afresh the process and make our own recommendations. But in the context of this report, we need to then ask the question, do we believe that the issues that were dealt with at the beginning to address the concerns have been thoroughly dealt with? And do we feel that these recommendations have been or should be taken forward? That will help us to move from where everybody was to be where everybody is. Then the next issue then is that we need to debate, in the light of all of that, whether the approach of the CRL does address these issues, whether it actually is bordering on anything being unconstitutional. So we put that as a separate issue. It is in that context that we are now able to then sit down with all involved. And to be honest, I did promise the churches that raised the issue that we will meet with them. But I had already sent a message to the Minister Hlabisa to ask him to reflect on the matter and come back to the committee. So I do believe that before we go very far, we would need both CRL and the minister to be addressing the committee on this matter. Then it will be possible to invite the other members who are objecting to a conversation together. I think we need to just also watch how we work on it so that we don't preempt what the ministry and the executive authority over this matter would have done before we actually, come in, because I think there's also a little bit of an overlap in terms of roles and responsibilities that we must guard against. Let me leave it at that for now and say, let's get the other members to comment, because I think more than anything, we need to kind of brainstorm in terms of the approach on the matter. Honorable Labuschagne, you're on the floor.
Thank you very much, Chairperson. Very difficult after your summary. I want to start out by saying a lot has already been said, and I want to refer to some of the context that Honorable Mahdipi gave, but I want to start off by saying, if we look at the freedom, the Constitution and the chapter on human rights, then every time that we have to deal with human behavior, it is very difficult, because there's a lot of people who believe that we can regulate human behavior by legislation. I think most of us in this committee knows that it is more or less an impossible task to regulate human behavior. Then in this case, it becomes more difficult to regulate human behavior connected with religion. Because religion is a very emotional thing for each and every person, or sometimes not emotional. And it is one of the things that the rights, our chapter on human rights protect and say you have the freedom of religion. Now, that is the principle I think we need to ask ourselves. And I think that is the conundrum that the TRL was in, because there is so much pressure from various religious groups that say this kind of behavior is not accepted and we have to do something about it. The bottom line for me is there are a lot of behaviors in this country that are not accepted, that are already being regulated, and nothing happens. Therefore, there is a lot of corruption in our country. Therefore, there is a lot of child abuse. Therefore, there's a lot of women abuse, a lot of all kinds of abuses, with a lot of legislation, and nothing changes, or very little changes, because human behavior is not something that you will really, in the end, change by legislation. You can only change that if that legislation is going to be implemented and is followed through by the courts and all those things. And our country does not have a good history with that. So that is the first thing. I think that is what makes it difficult for us to decide what is the thing that we have to tackle as for the CRL, but for us as a committee. And now I want to go to that. And my first question that I wrote down when this started is, what was the mandate of the CRL to go into what they've done? Was that a mandate that they decided for themselves? Yes, they said it came out of the committee, but Honourable Maglapi put the spotlight on that and said that report was not accepted by Parliament. So I think we have to start there and say, is this process now sanctioned by Parliament? Do we leave that? The same question you asked, Chair. Do we go on with that, or do we now start our own process? Then the last thing that I want to say is, my other question that I said is, I would like them to clarify to me if they say that it's a self-regulatory process. Now, self-regulatory means that you as the church community, or as the so-called Christian community, or whatever you want to call yourself, have to have the processes and the structures in your organization to deal with anything that is happening in your organization. If things happen that's not supposed to happen, like exploiting people, because most of these people are adults, they are not children. And if it's children, it's parents who take their children to these churches out of their own free choice. So those churches and those organizations have to have their structures and their systems on how to deal with that. That is self-regulation. To say that a code of conduct, that the CRL will look into a code of conduct with legislation, that is very confusing for the public, because the CRL can't make legislation. Parliament makes legislation. That's the only institution in this country that can make legislation. So that is a confusion, and that will just bring in more and more pressure on the CRL as well as on us. So for me, we need to decide, is this a process of legislation, or is this a process of consultation, not only with the Christian community, but with more than the Christian community, to see what does self-regulation means in the church or in the religious bodies, because if they can regulate their own behavior and their own code of conduct, that will help a lot. My opinion is, at the end of all this, is that is not for Parliament. It's not the state's position to regulate regulation, because it's a violation of the Bill of Rights. With that, I do recognize a lot of things that's going on that should not go on. But this will, I'm sorry to say this, but it sounds like the old apartheid regime, that you want to regulate each and everybody's behavior and the things that you don't like. Thank you, Chair.
Thank you, Honorable Labuskaghni. Let's get Mkalipi back.
Chair, I think as a way forward, and you also guided correctly, Chair, as you always do, I think let us withdraw this matter for now in this platform and go back as committee alone and try to find an approach that how are we going to deal with this sensitive matter. As chair, you also provided some questions to say we are not sure as a committee which report must we consider, which one we must not consider, especially when the report of 2018, which reflects here when the chair of the commission, when she do the presentation, keep on referring on it. But the fact of the matter, that report chair died on the 2018. But the previous committee also tried to deliberate on the very same matter. But if I check here, what is a bone of contention emanating from the presentation from the chair is that the Section 2022 committee, there are members, and she is clearly saying are coming from which church and what is the membership of each church. But with my small understanding of the issue now is that there is part of those people are calling themselves the defenders of the Christian. There's part of section of Christianity who are disputing the processes of Section 2022 that we think that we are going to get a report from. So therefore, I argue and I propose that let us withdraw this matter. Let us go back as only committee members and reflect on how is the approach on this matter. Once we agree as committee members, how do we move forward? Then we'll come again and ask the commission to come and also the people that march on the 13th of November to come and present and identify all other stakeholders who can also assist us if they are happy with the process to constitute sections 22 committee going forward without losing the sight of what the chair was talking about. This thing started when there was an outcry in the country. Remember, everyone was up in arms when the madness was taking place in the name of the religion. But for us, as the committee, as the chair also said, you have also engaged with the minister and all other stakeholders. Let us go back to a drawing board and then come back with a clear way forward, Chair. I propose. Thanks.
Thank you, Mkalipi. Van Zyl.
Thank you, Chairperson. I agree with what has been said by yourself, also Honourable Mkalipi and Honourable Labuskaghni, the most actually. And Chairperson, if we do take this route, which I think is the most sober route to take to halt the proceedings, just for now, just for us to recoup as a committee and see the legislative side of it and the legal side of it, where this report obviously had been lapsed, it never went to Parliament. I think we need to then also just bear in mind that the Section 22 committee must then stop the work until we instruct otherwise. Chairperson, that would just be my plea for now. Thank you.
Okay. I'm not going to bother the chairperson of CRL with a need to respond, because I think you obviously will have to go by the guidance of the committee. So I'm going to just suggest, based on what the members are saying and what the commission has come from, a tentative way forward that we can refine when the committee sits as a committee on its own. Firstly, what we would like to get would be, and this is what I was trying to get from the presentation, there's still a slight difference between what we got and what I was trying to get. So when the committee went to the portfolio, when the commission, the CRL commission went to the portfolio committee, what was your submission? So we need that submission. Secondly, we obviously need this report that you have just given as the second aspect of it. You have embarked on a process. What's involved in the process? As you have said, who did you agree with? Who didn't you agree with? You put it there, and then that's what we need to get as a committee. The second aspect, I have raised the matter with the minister. We would need the minister to also come and reflect to us what his approach on the matter is. That is going to help us to deal with what has happened from the side of the Commission and the ministry that oversees this matter. So those for me would be the first two issues that we need as a committee. Then thirdly, Honorable Mkhaliphi has referred to a letter from the Speaker. I haven't seen that. So we need to get our Secretariat to pull this report that we've just referred to of the previous meeting and any communication from the Speaker, and also just a confirmation of the status of this report that was taken by the committee. Is it still in Parliament? Was it adopted? Did it lapse? Is it in any way having a status that we can even refer to it? So that I think we need our secretariats to clean up. Having said all of that, I think we owe two groups to actually address us, just to hear them out on the matter. The first group is the group that sent the memorandum. What are their issues? I did promise that we will listen to them. The other group are those who have already been pointed out as having already been consulted and agreed. We need to know what is their point of view on this matter. Then at that point, I think this committee will be in a better position to make a pronouncement on the matter. Before that, it's going to be very tricky. I think we have to deal with a few fundamental issues. The first of those fundamental issues is that freedom of religion is protected by the Constitution. It's a fundamental issue, and we will not disagree about that. In the context, all of us are not disagreeing about the fact that there was no intention at any point for the state to regulate religion in the sense of the state being in charge of how people believe and all of that. On the other hand, there's a lot of abuse that has actually created a huge amount of public outcry. Sexual abuse, psychological abuse, financial abuse, lack of compliance with the legislation, and also the issues of, beating the people of being made to ingest unsavory items and all of that. Now, this parliament cannot be said to have condoned any of that under the guise of freedom of religion. So what is the approach and what is the best instrument of being able to contain those and deal with them? Then we can then talk about the question of what is the approach and the role of self-regulation as is being discussed. Is it each church for itself? Is it each faith group amongst itself? Is it interfaith? How does that work? Obviously, by the time we get to that, we'd have had to go through quite a lot of consultation and engagement and so on. At the end, there has to be a degree of a consensus on what we want to do as South Africans, that we can then take it forward as to whether it becomes a legislation or not. That's the last issue. So with that, for me, I would therefore say we'll halt this discussion. We will then request the CRL to give us the information that I've requested. We are going to invite the minister as well, with or without CRL, to also address us on this matter. We are doing that in preparation for hearing the two groups, those who are consultant and they've agreed, and those who are objecting. Then we can see. Now, there's a slight area of overlap of responsibilities, which both Honorable Mkalipi and Van Zyl are touching on, and I would go. I think we need a very steady consultative approach onto it. Can we as a committee order the commission to stop what it's doing? Or should we actually be addressing ourselves to the minister in terms of how this matter should be handled, and therefore deal with the minister's approach as the executive that is responsible? If you look at the legislation, I looked at the fact that there's reference to minister, and it says that's a minister who shall be designated by the president, and in this case, as a minister of COCTA. So there will certainly have to be an interaction with the minister before we could actually issue any kind of order or instruction, because we might actually just be transversing the separation of powers at that level. But that is something that I would like to deal with as a way of helping to guide as the committee moves along on the matter. That is how I think we should handle the matter. But I think, honorable members, we must all accept there's no other way this matter can be discussed without it being too sensitive and emotional. So at the end of it, we are the ones who must understand that all those who are involved are going to be emotional, are going to be very sensitive about it. But our approach should be to try and find a way of how South Africans across the religious divide or the faith or denominations divide are able to discuss a matter like this and come to a solution that will satisfy our people, that we have addressed the ills that they were concerned with, but at the same time that we have not broken the constitutional guarantee on the protection of religious faith, of rights of to freedom of religion for all individuals. So I think that balance is going to be tricky. We shouldn't be caught in it ourselves as being almost taking a view of one side or another. It might be tempting because the issues also affect us, but I think we need to avoid that, because someone somewhere needs to sober up and say, no, this is the best way of how we can pull this one together. I do believe that the solution will come when the different groups are all brought into one conversation, and then we are saying, okay, here are the problems, how do we solve them? How do we make sure that there's sustainability in the way we address them? And maybe the process of the CRL may not be necessary. It may be necessary with certain adjustment. Whatever that the situation might ultimately be, it should be an understanding that it's primarily a community matter. It's a societal matter that government can only act as an agent of the people. And from that point of view, I'd love to hold this discussion at that level. We can reflect on it as a committee in the absence of the other members. Ms. Mkwanazi, if you'd like to come in, and then we can then close it at that point.
Thank you, Honorable Chair, honorable members. Will be guided by yourselves after deliberating as to the way forward. Thanks a lot for hearing us.
Thank you very much. So we will then at this point excuse the CRL. Let us proceed then with the agenda. All the members of the CRL, we want to say thank you. And so may we get the agenda on the table again. Sherin? What is missing at this point is the briefing on the Municipal Structures Amendment Bill. Can we move on to that issue? Let me say to the honorable members of the committee, it's a bit tricky the way we are going to handle this matter, but let me start by saying we owe the committee a full briefing on our visit to Denmark. We owe this to explain what we went through and all of that. I must also say I approached the minister and asked if the minister would be giving us would be tabling the bill to the committee as it was originally suggested, that the bill would be coming through around November. I got an impression that this was not possible, and I thought we need to get a formal briefing from the minister on where the processes are. We are worried about timelines, and we would then be able to discuss that and also look at how we approach our visit to Denmark and as a committee. But I then asked the minister that even if we are not tabling in Parliament, let's have a kind of update briefing on this matter. That's the context with which we've brought this matter. It will allow us to be able to discuss our Denmark issue in context, and so I'm requesting that we allow the we allow the department to take us through. Thank you very much. Dr. Naidu, please proceed.
Thank you very much, Honorable Chairperson, Honorable members of the committee, Honorable Deputy Minister, DG, and colleagues. Pardon my voice, I've been doing a lot of talking these days. Chair, we have prepared a presentation, but I see that it is parked at the point where we would be talking to the time frames. Maybe, I'm not sure who's flighting, to put it onto presentation mode. So we could go to the timelines, which are on the next slide. Maybe in one or two sentences, Chair, to say that the point at where we are now is that after having met with the chief whip of the Democratic Alliance on 2 occasions, in June and in September, we had considered the private members' bills, the 2, and those issues that were provided for in those bills have, to a large extent, been covered in the revised bill that the department has prepared. What is outstanding was that we had said to the private member the issue relating to the independent panel. As COCTA, we would want to reflect on it a bit more. And then the second matter relating to the thresholds that was being proposed in the private member's bill, together with 3 other options that we had as COCTA developed, subjected to legal opinion. It had taken us some time through the state attorney to commission senior counsel. We have commissioned 2 separate senior counsel to look at the 4 options that we had before us. And that was done in September already. We're waiting. In fact, earlier today, we had received a draft opinion from one of the senior counsel, and then we still await the other, which then takes me to the number 1 on the actions that we see in this table. The 20th, we were hoping that by Thursday this week, we would receive the two opinions from the two teams. Having considered that, and that which would be acceptable in terms of the options on the thresholds would then be included into the revised bill. And we would want to do that by early next week, Monday in particular, to present that thereafter to our principals administratively and in the ministry during the middle of next week. And then as is required, we would then submit the bill to the Office of the Chief State Law Advisor for certification. Parallel to that, we would need to also engage the presidency to get the socioeconomic impact assessment study certificate, which we would then take with us to the various clearinghouses before we get to cabinet. Realistically speaking, Honorable Chair, if we get through the clearinghouses, we expect to get to cabinet by, let's say, February, the early meetings of cabinet in the new year. And once that is done, we would then introduce the bill into Parliament. I will pause there, Chair, and I'm not sure if that would suffice in terms of the update that the committee wanted in terms of the processing of the bill. Thank you.
No, don't stop there. That's fine. We'll come back to this issue. Deal with the highlights of what you agreed with, what is incorporated, what you didn't agree, what is remaining for threshing out. Then we'll have to have the committee come in.
Okay. So maybe if I'm not sure if it's operating, to go to the beginning of the presentation, and I will guide from there. Yeah, maybe the next slide. So, Chair, you will see from the presentation that we had shared yesterday, the background talks to three bills.
You can do it in 10 minutes, isn't it?
Yeah, I can, Chair.
So, thank you.
The three bills refer to the bill that was published by Cooperative. This is the bill, the 8 clauses therein, and we provide it at a very high level. Bill number 2 on the second slide talks to on the next slide, talks to the first private members bill. I'm not going to go through the commentators on the bill that we had published for comments. On the next slide, you would see that on the left-hand block, it talks to the private members bill, the first one, the time frames that were being proposed, the second major matter relating to the threshold. So in relation to the first bulleted point, those matters that were proposed there, we've accepted and included into the revised bill. The second private members bill in the green block speaks to motions of no confidence to be done once in 12 months, and then other matters relating to motions if there is a violation of the Constitution, proven misconduct, and poor performance included in the bill. The matter relating to the independent panel chair is the matter that I had indicated earlier we would want to reflect on as Cooperative before we finalize our position on that matter. On the next slide, the threshold options, you would see there's 4 on the extreme left, first one being that which we had proposed in the bill that we had subjected to public consultation. It was the 1%. The second option is the option where we suggest that the ward election and the PR election be considered as 2 separate elections, where in the event that a candidate or a party loses a ward, those votes that would have been obtained through that election does not go into the pot of total valid votes. The third option is the option that was sponsored by the private member, and what says that in order to be considered for consideration on the municipal council, you would need to win a seat in the first round, but not to pick up seats when the remainder method is applied after round one of the allocation. So, fourth option deals with, in the main, trying to do away with the kingmaker, where in some instances you have parties with minimal seats occupying positions in the executive. So, for example, to do away with an instance where you have a council of 270 and the party that picked up just one seat becomes the mayor in that municipality. Those were the four options. Those that we are subjecting to legal counsel opinion. On the next slide. At the instance that we had met with the private member in September, these issues were raised around the thresholds. And at that point, the private member had indicated that they would want to also get their own opinion on the threshold matter. They had commissioned Cohen Senior Counsel, who had then provided those following comments in the block that is highlighted or shaded in the pinkish color, to say that, one, the threshold matters would not pass the constitutional muster, and then cite certain case law. The executive threshold, the matter dealing with the kingmaker issue, will result in absurdities, and then also commentary on the ward threshold proposal that we had put forward as Cooperative. In the next slide, we had also considered for inclusion in the bill the matter relating to the prescribing of qualifications for councillors, but knowing fully well that Section 1 of the Constitution provides that every adult citizen has universal adult suffrage if you are eligible to vote, eligible to hold public office. So we wanted to tread carefully there, not to prescribe qualifications for ward councillors, but rather to see how we would want to put in place a competency framework, competence meaning expertise, qualifications, etc., with those that would occupy executive position in municipalities, such as mayor, speaker, chief whip, but then also to see how that could be extended to chairpersons of certain committees. So, for example, in the MPAC, we would want to say that the chair of that committee should have certain prescribed qualifications. The meeting of June, but this is actually an error. The meeting of September resolved that Cooperative will seek legal opinion on these matters, which are indicated on the next slide. That we had instructed the state attorney on the 21st of September to commission 2 teams of senior counsel. It was a challenge getting the teams onboarded. We had preferred certain senior counsel to be appointed. They were not available, but also in terms of the state attorney's own programming processes, they need to, not use the same consultants or the same senior counsel all the time. So we had a bit of a challenge. It was only late October that we finally managed to appoint Advocate Neil Priya Senior Counsel, he's junior, and then Advocate Shanson Senior Counsel with Advocate Rasakale to support on the matter. That share would then take us to the timelines, which I have spoken to already. And then we'll hand back to your good staff for the committee to note the comments and the proposed timelines that we have penned. Thank you very much, Chair.
Thank you, honorable members. Let me then explain. Thank you, Dr. Naidu. Let me explain what the intention of this briefing was. The intention is not to discuss the choices in the bill. The challenge the committee was facing is this. We had a bill submitted to us, which was a private member's bill. We referred it to the minister. That process gave us an impression that by November, there will be the bill from the department. Now that we're getting a sense that the bill is not coming through, we need to know what is the status of the private member's bill so that we can then see how to take the matter forward. From what the briefing is coming up, it's indicating that a lot of what was in the private member's bill has been incorporated in the bill coming from the department, which means we'll consider everything as one bill when it comes. So that was the main reason why we needed to know where are we on the issue of the bill. But when the bill comes and when we discuss this matter, maybe in relation to the revisit to Denmark, we could then go to the details of the choices and the various views about what we think should happen and so on. But the idea was not to do that in this sitting. Then we can then comment about the timelines, we can comment about everything else, but the idea is not for us to start getting into this matter, into the details, other than the fact that we did ask the minister to look into this bill. We're not really got, although I had been interacting with the process, we hadn't really got a formal, latest formal update as to where we are. So when I asked the minister to come in and table this, then I heard that the bill is not ready, and so that's why I said, no, somebody must come and explain to the committee. That's where we are, members. I would like you to make your comments. Honorable Labuskaghni.
Chair, thank you very much for that guidance. I am a little confused. I thought that there was a decision made that the private member, based on the agreement between Honourable Michelakis and the Honourable Minister, that there was an agreement that will now be a departmental bill. I'm just have to make sure that that is how I understand it, or otherwise be correct.
No, sorry, Honorable Labuskaghni, you are quite correct. The issue is there is one bill because they've taken a lot from the private members bill, incorporated, and then whatever remains for debate is for us to debate. So your understanding is correct. We just needed an update, but you can proceed.
Okay, thank you. Then the other one is just a simple question, and I don't know if they will give us that now, and it's not that urgent, but I would like to know if they already have an indication of if all these processes has been shown to us done, what would be the tagging of this bill? Will it be a 75 or a 76? And if they say this bill is coming to Parliament then in February, so that we can also request that this bill can be seen as a priority to be fast-tracked. If it's tagged as a 76 bill, to be able to go through the whole required parliamentary legislative process in Parliament next year. Thank you, Chair.
Very important point that you have raised. There isn't a way this bill can end up at the National Assembly and doesn't go to the provinces. It will have to. So anyway, let them respond to that issue. And I think you're already raising the issue that was my basis of my restlessness. Initially, I believed that this bill could be processed in such a way that it might have an impact on next year's elections. From this discussion now, there's no hope that that can be the situation. I don't know how well we can fast-track it such that it does that. So I think your point is important and relevant, and I hope that department will come already having considered all of that. Honorable Direko?
Thank you, Chair. I'm glad that the honourable member and the department were able to work around the bills and make it one bill, which makes our work easier as the committee. However, Chair, I'm concerned about the time frame because the reason why we're pushing for these bills is because we wanted to have this bill finalized before the election so that we can implement whatever that we could have agreed on when we go to the local government elections. Noting the state of our electoral outcomes where there's a possibility that we may find many municipalities under coalition government, and if we are not fast-tracking the bill, it simply means that by that time we'll still struggle with the same situation that we find ourselves in, such as the one of your city of Tshwane and the city of Johannesburg. However, we note the progress, but I'm really not happy with the time frame because it does not serve the main purpose for this bill. And bearing in mind that the reason why we went to the study tour in Denmark was because we wanted to make a meaningful input on the bill so that when we go to local government, all our systems are ready. So failure to finalize this bill, it simply means that the department could have failed on one of their mandate because we have a responsibility to ensure that our municipalities are stable politically and we have proper system to manage whatever that could be the outcomes of the local government election, noting from the experience that we have come from. Thank you, Chair.
Thank you, Honorable Mkalipi.
Chair, one of the things that we learned from Denmark, of which we must find a way to implement it here in South African Parliament, is that Denmark processed their bills within a month. And I agree with Honorable Dereko that in these time frames is going to disorganize us big time. One of the reasons is that we want to have this bill before local elections that is taking place approximately in November next year. But with this time frame that the doctor has shared with us, it looks like we are not going to finalize this bill before the local government election. So therefore, Chair, I think let us find a way to get our report of the study tour, also to say to the parliament, these are the things that we learned during our oversight. So therefore, let us align ourselves as the parliament and what we have learned in Denmark. Thanks, Chair.
Thank you, Honorable Labuskaghni.
Thank you very much, Chair. Thank you for the second part on that. I tend to differ that it's not possible to do this bill. It is possible, given that the department now can give us the undertaking that they will prioritize the bill. If this bill can be presented to Parliament or come to the committee in February this year, the rules of Parliament gives a clear indication of the time frames of bills in each house. There is a minimum of 6 to 8 weeks in the NA and a minimum of 6 to 8 weeks. And I can't remember clearly because the rules has been amended. It might be 8 to 10 weeks now. That gives us 4 months. If we have this bill in February, there will be enough time to go through the work, but that means that when the bill comes to Parliament, Chair, this committee has to prioritize that bill. That bill has to be dealt with immediately, go through the processes of taking it on public participation to the provinces, get the feedback, even if we have to meet sometimes more than we need to meet. But if we say we prioritize this bill, because this is not for this or that, this is one of the big issues and one of the big undertakings of the white paper and of this committee is to stabilize and to try and see if we can contribute into bringing some stabilizing factors into local government. Now, if we are not going to prioritize this and if we are not going to commit to work according to what prioritization takes of us, then we are all failing ourselves in this committee as well. So my plea will be to the department to make sure that they keep the timelines, because it's been moved from November to February. That in itself gives, we are losing 2 months, or now we know that nothing is, not nothing, that but public participation over December is not great. So therefore, I agree with it coming to Parliament in February. But then we have to prioritise it, and I've said it now 6 times, for us to have this bill being done and went through Parliament in the following 6 months that's left. Thank you.
Can I ask you, Honorable Labuskar, what guarantee can you give this committee that the Democratic Alliance will not take it to Constitutional Court? So when we think we've fast-tracked it, then it gets delayed in court. Honorable members, I'm on...
You asked me, can I answer to you? I'm not the spokesperson of the DA, but
I didn't want you to answer it, actually.
No, but that would be unfair. You can't raise that question and not let me answer it to you.
No, that's fine. That's fine. That's fine. Proceed.
I'm not the spokesperson and or the leader and or the chair of the legal department of the DA. My experience throughout all the years in all spheres of government with all parties is when we negotiate with parties and or with organizations, and we have an agreement, we don't go back on that agreement. And as far as I know, there's an agreement has been set out by the department now, and as long as the proposals from the ANC when it goes to the provinces is keeping within that agreement, we won't fight it. So this is what it is. Okay. It does not get the little G in you the committee chair.
I was only teasing you, but my point. I could see you're throwing back the stones. No, but honorable members, I think we need to find a way to express the sentiment. Firstly, that the timelines that are proposed are of concern to us as a committee. I think this committee is more than ready to deal with this bill. And in fact, we are actually being delayed. But we do understand that there are procedural steps that have to be dealt with. Otherwise, the whole thing might also fall flat in front of our faces. So from that point of view, we should just urge the minister that we really need to look at an earlier than a later timeline. That means urge all the participants to move with speed to process this matter. Then once that's been done, we also need to start preparing our approach as the committee so that we can actually get this matter dealt with within as speedy a time frame as might be possible. So that will help us quite a lot, but also a lot of bilateral discussions might be necessary to see how we can take the matters forward. The issues of challenging the bill remain a reality, especially from parties which might be having concern that they might be cut out on the issue of threshold. From where I sit, there is nothing wrong with the threshold, it's constitutional, but the political disagreement is going to be whether parties think they'll make it or not, and therefore they'll be arguing from self-interest. They will not be arguing from whether they think maybe ruled constitutional or not, irrespective of whether they call it a constitutional exclusion or not. So the question that we need to try and work on has to be about where we can have influence in the process of fast-tracking the bill. At the provincial levels, we need to also engage parties to try and garner as much support as might be necessary. The question of whether between the tabling and the processing and the finalization, there will be enough time to actually implement the bill is another question, because obviously those who are preparing for elections must already be privy to the legislative framework that they'll be using, that they'll be conducting elections under. So from that point of view, it's going to become important that we must really have all our ducks in a row, as it were. So I'm going to ask that we deal with our teams on the legal side. Shireen, let's involve our team. Let's look at the timelines and actions from the point of view of this committee, so that we can table now, maybe next week, to say this is what we could do to fast track the process. Then wait, so that when the bill hits the parliamentary table, and of course we let everything run as already pre-planned. That would be the way. So I do agree with the members who are saying, let's have our discussion on the issue of the visit to Denmark and submit it to Parliament. I think it would be a good start on the debate if that had to be included. And then, of course, we move it from there. I think next week we might have a bit of time to focus onto this issue. But otherwise, honourable members, I think our approach, as it were, on this matter is we are ready for the bill. We must just ask the minister to fast track. Let's still try and target a fast tracking approach that will allow this bill to still be available for the next election. Then we get Dr. Naidu, and then of course I see the Deputy Minister wants to come in. I'm not sure who else from the department wants to come in, but can we allow the departmental team to respond? Let's start with Dr. Naidu, and then we can move to the Deputy Minister or anyone else that is needing to comment. Thank you very much.
Yeah, maybe two things. The first is that the tagging of the ball will be done by the tagging mechanism in Parliament, but I think all things point to it being a Section 76 bill. The second thing is that, of course, we will try our very best to make sure that the legal opinions that we sought are brought in as soon as possible. And then that which we want to do is to see how it informs the final version of the bill, and then to take it to the subsequent stops, be it the State Law Advisor, the Presidency, and then to the Cabinet. I'll stop there, Chair. Thank you.
Thank you, Dr. Naidu. Deputy Minister, Honorable Benson Gamashe.
Thanks very much, Honorable Chair of the committee, honorable members. I just wanted to make an undertaking, Honorable Chair, that we have noted quite clearly the concerns of the committee regarding the impact of the timelines into the whole process, and the need to inject some expeditious efficiency to finalize the processes concurrently with the oncoming electoral outcomes, so as to enable the stability and functionality of the envisaged newly established municipal councils. We really note that. And secondly, we also lean towards appreciating the fact that the bill, in the nature of the issues to be considered, it is likely to be tagged as a Section 76 bill, with, of course, the invocation of the provision of section 154 subsection 2, as there are significant and material issues that will affect municipalities and related institutions. Thirdly, on a lighter note, appreciating the oomph and perhaps as the ministry we will appreciate that even when the bill is approved by cabinet relating to traditional and Khoisan leadership, it be expedited as well, because it will have an impact on how traditional leaders will be represented in the municipalities in terms of Section 81 of the Municipal Structures Act, as would have been amended to address the current constraints which have been experienced through the process of the current municipal administration. Thanks so much, Mavovo, for giving us the opportunity. Thank you once again.
Thank you very much, Honorable Deputy Minister, and thanks for making that undertaking to share our sentiments with the Minister and the Ministry. It will help us if everyone can see the agency on this matter, because the committee is very willing and ready to assist in fast-tracking. And we also believe that it would be a very significant value add to the next year's elections if this can be dealt with. Certainly, the committee is ready to assist and cooperate. On the one bill on the National House of Traditional Leaders and Khoisan Bill, the Traditional Leadership and Khoisan Leadership Bill, the issue for us is not more with the committee. The issue is more on the consultative processes that would be good to discuss the alignment of how those consultations would be done so that we can reduce the possible fallout in the consultative process that will make it unnecessary for the matter to go back to Constitutional Court. You recall that we are here because the objection came from outside the committee. It actually came to criticize the approach of Parliament in this bill. So we do need to confer. I'm not quite convinced that you can rush it in the same way that we would have rushed this one on the coalition's bill. But nevertheless, we will stand ready to fast track as much as we can. So come and engage us. Let's see where we need to deal with this matter. But from where we sit, the sooner the department tables, the sooner we shall assist in fast tracking. Having said so, I want to say to the honorable members, thank you very much. Thanks, Dr. Naidu. Thanks to TM and the rest of the team. At this point, we would like to thank all the commission that was here, CRL and CGE, the Director General of Traditional Affairs, and the whole team from COCTA who have been here. Thanks very much. We now excuse you as we look at the last housekeeping matter of the committee program going forward. So can we ask Shireen to share that? The committee will look at this, and that's the last item before we close. Thank you very much. Shireen, please share that.
Bye-bye.
Thank you.
Thank you. I don't think you should take it off the screen. I think you should leave it there. We hopefully will get time for in that physical meeting to look into the question of Denmark post-mortem or discussion on the study tour to Denmark. I think this let's have that as the other item. We're still engaging these municipalities to get them to commit on these dates. And so if there's any change, we'll talk about them, but it would be of interest to us. It would be in our interest to close this chapter on these particular municipalities that are outstanding so that you can then proceed to focus on the other provinces. I'm aware that there's a lot of interest in our visit proposed to KwaZulu-Natal, particularly from the other committees. They've approached me to say, when are we going to KwaZulu-Natal? I have said that we will have time probably early in the year. So I don't think that should appear in this year's program. They will see that we are going to have a briefing from the IEC. This is at the request of the chairperson of the Home Affairs Portfolio Committee. And then we need to look at adoption of those reports and then close the year. That is the proposal as we go forward. If members would like to make any comment, that's open for that.
Chair, what are you saying about KZN outstanding oversight, Chair?
I am saying we will not be able to accommodate it this year now. It looks like we've run out of time. The other committee members from the Joint Oversight Committee team have been asking me about it. When are we going to KwaZulu-Natal? So I've said we will never make a mistake of leaving them behind. We don't have the time now. We'll probably do that beginning of the year. That is the point about KwaZulu-Natal.
Okay, Chairman.
Thank you. Any other comments? This is work in progress. Okay, honorable members, this brings us then to the end of the meeting. I want to thank all of you for your participation and contribution. As I've also done, I want to again thank the CGE and the CRL, the commissions for their presentations, the Deputy Minister, Head of Department or the Director General of Traditional Affairs, and all the staff, Dr. Naidu, for all their submissions. Thanks very much. At this point, we shall meet in person. A physical meeting will be next Tuesday, and please enjoy the rest of the week. The meeting is adjourned. Thank you very much. Meeting adjourned.
Thank you, Chair.
Thank you, Chair. Thank you, Chair.
Thank you very much. Thank you very much.
Thank you, Chair. I'm sorry, I was in and out. Problem was.
Sorry about that.
Yeah, I couldn't contribute, Chair. I'm sorry.
No problem, but at least we followed some part of it.
Thank you, Chair.
Welcome, thank you. Thank you, members.
Thank you, Chair.
Thank you,
Chairperson.
Yes, thanks, Saints. Thank you. Meeting is adjourned.